Thank you, Reverend. The House will come to order. For a second week in a row, please join Representative Woog in the Pledge of Allegiance.
Please join me with pride in our Pledge of Allegiance. I pledge of allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Mr. Gregorio, please call the roll.
Representatives Amabile, Aiken, Baisley, Benavidez, Burnett, Byrd, Bockenfeld, Basenecker, Bradfield, Caraveo, Carver, Catlin, Cutter, Doherty, Duran. Represent Escar, Exum, Froelich. Representative Froelich. Representative Froelich is excused. Geithner. Oh. Gonzalez Gutierrez. Gray. Hanks. Herod. Holtorf, Hooten, Jackson, Judah, Kennedy, Representative Kennedy. Representative Kennedy is excused. Kipp, Larson, Montine, Luck, Representative Luck is excused. Lynch, McCluskey, McCormick, McKean, Representative McKean, Rep. McLaughlin.
Good morning.
Michael Sinjane, Mullica, Neville, Ortiz, Pelton, Pico, Ransom, Rich, Ricks, Roberts, Sandridge, Sirota, Snyder, Soper, Sullivan, Tipper,
Here.
Tatone, Valdez A, Valdez D, Van Bever, Van Winkle, Weissman, Will, Williams, Woodrow, Woog, Young, and Mr. Speaker.
With 64 present, one excused, we have a quorum. Representative Woog.
Thank you, Mr. Speaker. I move that the Journal of Friday, June 4th, 2021 be approved as corrected by the Chief Clerk.
Members, you have heard the motion that the journal be approved as corrected by the Chief Clerk. All those in favor say aye. Aye. All those opposed, no. The ayes have it. The motion is approved. Announcements and introductions. Representative Byrd.
Thank you, you, Mr. Speaker. Members, if it is Monday, it is finance. And it's not just finance, it's super finance. So upon adjournment, we will be hearing Senate Bill 33, Senate Bill 273, Senate Bill 60, and Senate Bill 293. So friends and fans of finance, come join us. It will be fun.
Mr. Gregorio, committees of reference.
Committee on Energy and Environment, after consideration on the merits, the committee recommends following. Senate Bill 264 be amended as well as be so amended and be referred to the Committee on Appropriations with favorable recommendation.
Representative Weissman.
Thank you, Mr. Speaker. Good morning, members. Judiciary Committee announcement. Members, obviously we did not meet this morning at 8:30. We do have one more bill to bring back up for action only. That is SB 176. We're going to meet sometime later this afternoon, I think after Finance. I will keep in touch with who needs kept in touch with, and I will come down here and announce that again as soon as I can as to what the timing is. Please stay tuned. Thanks.
Representative Harrod.
Thank you, Mr. Speaker. Appropriations members, we will be meeting this morning. On the calendar is 137, 240. 180 will be laid over. We also have 264.
Any other further announcements and or introductions? Seeing none. Majority Leader Escar.
Thank you, Mr. Speaker. I move that we proceed out of order for the immediate consideration of third reading of bills.
Great. Members, you have heard the motion. Seeing no objection, we'll proceed out of order for immediate consideration of third reading bills. We will do a few third readings before we break for appropes. Majority Leader Escar.
Thank you, Mr. Speaker. I move to proceed out of order for immediate consideration of House Bill 1320. It is on page 5 of your calendar.
Seeing no objection, we'll proceed out of order for immediate consideration of House Bill 1320. Mr. Gregorio, please read the title of the House Bill 1320.
House Bill 1320 by Representatives Tipper and Benavides, also Senator Lee, concerning the continuation of the Sex Offender Management Board and in connection therewith implementing the recommendations of the 2019 Sunset Report by the Department of Regulatory Agencies.
The motion before Majority Leader Escar.
Thank you, Mr. Speaker. I move House Bill 1320 on third reading, final passage.
The motion before us is the adoption of House Bill 1320 on third reading and final passage. See no further discussion. Mr. Gregorio, please open the machine and members, please proceed to vote. Representative McLaughlin, how do you vote?
Yes.
Representative McLaughlin votes yes. Representative Tipper, how do you vote?
Yes.
Representative Tipper votes yes. Please close the machine. With 49 aye votes, 15 no votes, and 1 excused, House Bill 1320 is adopted. Co-sponsors. Please close the machine. Majority Leader Escar.
Thank you, Mr. Speaker. I move to proceed out of order for immediate consideration of House Bill 1327 on page 6 of your calendars.
Seeing no objection, we'll proceed out of order for immediate consideration of House Bill 1327. Mr. Gregorio, please read the title of the House Bill 1327.
House Bill 1327 by Representatives Ortiz and Van Winkle, also Senators Colker and Woodward, concerning the authority of a pass-through business entity to elect to pay state income taxes at the entity level.
Majority Leader Escar.
Thank you, Mr. Speaker. I move House Bill 1327 on third reading, final passage.
Question before us is the adoption of House Bill 1327 on third reading and final passage. See no further discussion. Mr. Gregorio, please open the machine and members, please proceed to vote. Representative McLaughlin, how do you vote?
Yes.
Representative McLaughlin votes yes. Representative Tipper, how do you vote?
Yes.
Representative Tipper votes yes. Representative Byrd, Weissman, Woodrow. Please close the machine. 59 aye votes, 5 no votes, and 1 excuse. House Bill 1327 is adopted. Co-sponsors. Please close the machine. Majority Leader Esker.
Thank you, Mr. Speaker. I move to proceed out of order for immediate consideration of House Concurrent Resolution 1002 at the bottom of page 6.
Seeing no objection, we'll proceed out of order for immediate consideration of House Concurrent Resolution 1002. Mr. Gregorio, please read the title of the House Concurrent Resolution 1002.
HCR 21-10002 by Representatives Geithner and Kennedy, also Senators Lundin and Bridges, submitting to the registered electors of the state of Colorado an amendment to the Colorado Constitution concerning the extension of the property tax exemption for qualifying seniors and disabled veterans to the Gold Star spouses of deceased members of the United States Armed Forces.
Majority Leader Esker.
Thank you, Mr. Speaker. I move House Concurrent Resolution 1002 on third reading, final passage.
Question before us is the adoption of House Concurrent Resolution 1002. See no further discussion. In a one quick second, Mr. Gregorio, please open the machine. Members, just a reminder that this is a House Concurrent Resolution and requires 2/3 vote. Mr. Gregorio, please open the machine, and members, please proceed to vote. Representative McLaughlin, how do you vote?
Yes.
Representative McLaughlin votes yes. Representative Tipper, how do you vote?
Yes.
Representative Tipper votes yes. Please close the machine. With 64 aye votes, 0 no votes, and 1 excused, House Concurrent Resolution 1002 is adopted. Co-sponsors. Representative McLaughlin, co-sponsor. Please close the machine. Majority Leader Esker.
Thank you, Mr. Speaker. I move to go back to the top of the third reading of bills calendar, starting with Senate Bill 18.
Seeing no objection, we'll proceed out of order for immediate consideration of Senate Bill 18. Mr. Gregorio, please read the title of the Senate Bill 18.
Senate Bill 18 by Senator Moreno, also Representative Esker, concerning continuing the necessary document program indefinitely in connection therewith, making an appropriation.
Majority Leader Esker.
Thank you, Mr. Speaker. I move Senate Bill 18 on third reading, final passage.
Question before us is the adoption of Senate Bill 18 on third reading and final passage. See no further discussion. Mr. Gregorio, please open the machine, and members, please proceed to vote. Representative McLaughlin, how do you vote?
Yes.
Representative McLaughlin votes yes. Representative Tipper, how do you vote?
Yes.
Representative Tipper votes yes. Representative Bockenfeld, Catlin, Judah, McKean. Please close the machine. 44 aye votes, 20 no votes, and 1 excuse. Senate Bill 18 is adopted. Co-sponsors. Please close the machine. Mr. Gregorio, please read the title of Senate Bill 146.
Senate Bill 146 by Senator Lee, also Representative Bacon, concerning measures to improve prison release outcomes in connection therewith, making and reducing an appropriation.
Majority Leader Esker.
Thank you, Mr. Speaker. I move Senate Bill 146 on third reading, final passage.
Question before us is the adoption of Senate Bill 146 on third reading and final passage. See no further discussion. Mr. Gregorio, please open the machine, and members, please proceed to vote. Representative McLaughlin, how do you vote?
Yes.
Representative McLaughlin votes yes. Representative Tipper, how do you vote?
Yes.
Representative Tipper votes yes. Callan. Please close the machine. With 40 aye votes, 24 no votes, and 1 excuse, Senate Bill 146 is adopted. Co-sponsors. Please close the machine. Mr. Gregorio, please read the title of Senate Bill 199.
Senate Bill 199 by Senators Hawkins, Lewis, and Winter, also Representatives Escar and Gonzalez Gutierrez, concerning measures to remove barriers to certain public opportunities in connection therewith, making an appropriation.
Majority Leader Escar.
Thank you, Mr. Speaker. I move Senate Bill 199 on third reading, final passage.
Question before us is the adoption of Senate Bill 199 on third reading and final passage. Seeing no further discussion, Mr. Gregorio, please open the machine and members please proceed to vote. Representative McLaughlin, how do you vote?
Yes.
Representative McLaughlin votes yes. Representative Tipper, how do you vote?
Yes.
Representative Tipper votes yes. Please close the machine. With 41 aye votes, 23 no votes, and 1 excuse, Senate Bill 199 is adopted. Co-sponsors. Please close the machine. Mr. Gregorio, please read the title of Senate Bill 169.
Senate Bill 169 by Senator Buckner, also Representatives Ricks and Escar, concerning protecting consumers from unfair discrimination in insurance practices.
Majority Leader Escar.
Thank you, Mr. Speaker. I move Senate Bill 169 on third reading, final passage.
Question before us is the adoption of Senate Bill 169 on third reading and final passage. See no further discussion. Mr. Gregorio, please open the machine and members please proceed to vote. Representative McLaughlin, how do you vote?
Yes.
Representative McLaughlin votes yes. Representative Tipper, how do you vote?
Yes.
Representative Tipper votes yes. Representative Gray. Representative Gray. Please close the machine. With 41 aye votes, 23 no votes, and 1 excuse, Senate Bill 169 is adopted. Co-sponsors. Please close the machine. Majority Leader Escar.
Thank you, Mr. Speaker. I move to proceed out of order for immediate consideration of Senate Bill 289.
Seeing no objection, we'll proceed out of order for immediate consideration of Senate Bill 289. Mr. Gregorio, please read the title of Senate Bill 289.
Senate Bill 289 by Senators Moreno and Rankin, also Representatives Harrod and Byrd, concerning the creation of a cash fund consisting of certain money that the state receives from the federal coronavirus state fiscal recovery fund so that the money is available for appropriation only in other legislation.
Majority Leader Escar.
Thank you, Mr. Speaker. I move Senate Bill 289 on third reading, final passage.
Representative Byrd and Harrod.
Thank you, Mr. Speaker. I move for permission to offer a technical third reading amendment.
Okay, and that motion is in order. Let's display the amendment and explain why. Representative Byrd.
We have a drafting clarification where on a part of the bill we have used the words effective date and need to instead substitute the word passage.
Any further discussion on the motion to grant permission for a third reading amendment? Seeing none, the question before us is the motion to grant permission to offer a third reading amendment. Mr. Gregorio, please open the machine and members please proceed to vote. Representative McLaughlin, how do you vote?
Yes.
Representative McLaughlin votes yes. Representative Tipper, how do you vote?
Yes.
Representative Tipper votes yes. Representative Bockenfeld. Please close the machine. 46 aye votes, 18 no votes, and 1 excuse, permission is granted to offer a third reading amendment. I need someone to move the amendment. Majority Leader Escar.
Thank you, Mr. Speaker. I move Amendment L003 to Senate Bill 289.
Question before us, seeing no further discussion, is the adoption of L003 to Senate Bill 289. Mr. Gregorio, please open the machine and members please proceed to vote. Representative McLaughlin, how do you vote?
Yes.
Representative McLaughlin votes yes. Representative Tipper, how do you vote?
Yes.
Representative Tipper votes yes. Benavides, Gonzalez, Gutierrez, Gray. Representative Gray. Please close the machine. With 45 aye votes, 19 no votes, and 1 excused, L003 is adopted. Majority Leader Escar.
Thank you, Mr. Speaker. I move Senate Bill 289 as amended on third reading, final passage.
The question before us is the adoption of Senate Bill 289 as amended on third reading and final passage. See no further discussion. Mr. Gregorio, please open the machine and members please proceed to vote. Sorry. Representative McLaughlin, how do you vote?
Yes.
Representative McLaughlin votes yes. Representative Tipper, how do you vote?
Yes.
Representative Tipper votes yes. Please close the machine. With 41 aye votes, 23 no votes, and 1 excuse, Senate Bill 289 is adopted as amended. Co-sponsors. Please close the machine. Mr. Gregorio, please read the title of Senate Bill 291.
Senate Bill 291 by Senators Fenberg and Holbert, also Representatives Roberts and Van Winkle, concerning the transfer of $40 million to the Colorado Economic Development Fund for the purpose of providing grants to businesses and for investing in economic development opportunities in response to the negative economic impacts of the coronavirus pandemic from the newly created Economic Recovery and Relief Cash Fund, which fund consists of certain money that the state receives from the federal coronavirus state fiscal recovery fund in connection therewith making an appropriation.
Majority Leader Escar.
Thank you, Mr. Speaker. I move Senate Bill 291 on third reading, final passage.
Representative Roberts.
Thank you, Mr. Speaker. We ask for permission to offer a third reading amendment on Senate Bill 291.
Great. We'll have it displayed. Oh, man. Man. Those squeakers, some of them are broken.
They're wearing out.
Explain why, Representative Roberts.
Thank you, Mr. Speaker. So this is the same amendment as the previous bill. It's in the effective clause because this relates to a different bill that we need to change effective date to passage.
Any further discussion on the motion to grant permission? Seeing none, the motion before us is to grant permission to offer a third reading amendment. Mr. Gregorio, please open the machine and members please proceed to vote. Representative McLaughlin, how do you vote?
Yes.
Representative McLaughlin votes yes. Representative Tipper, how do you vote?
Yes.
Representative Tipper votes yes. Kennedy, Representative Tipper voted yes. Please close the machine. With 54 aye votes, 10 no votes, and 1 excuse, permission is granted to offer a third reading amendment to Senate Bill 291. Representative Roberts.
Thank you, Mr. Speaker. I move L003 to Senate Bill 291.
The question before us is the adoption of L003 to Senate Bill 291. See no further discussion. Mr. Gregorio, please open the machine and members, please proceed to vote. Representative McLaughlin, how do you vote?
Yes.
Representative McLaughlin votes yes. Representative Tipper, how do you vote?
Yes.
Representative Tipper votes yes. Representative Ricks. Representative Ricks. Representative Bockenfeld. Please close the machine. With 55 aye votes, 9 no votes, and 1 excuse, L003 is adopted as Senate Bill 291. Majority Leader Escar.
Thank Thank you, Mr. Speaker. I move Senate Bill 291 as amended on third reading, final passage.
Question before us is the adoption of Senate Bill 291 as amended on third reading and final passage. See no further discussion. Mr. Gregorio, please open the machine and members please proceed to vote. Representative McLaughlin, how do you vote?
Yes.
Representative McLaughlin votes yes. Representative Tipper, how do you vote?
Yes.
Representative Tipper votes yes. Please close the machine. With 53 aye votes, 11 no votes, and 1 excuse, Senate Bill 291 is adopted. Co-sponsors. Representative McLaughlin, co-sponsor. Please close the machine. Majority Leader Escar.
Thank you, Mr. Speaker. I move Senate Bill 242 on third reading, final passage.
I think, so well, that's fine, we're in order. Let's hold on 1 second. Mr. Gregorio, please read the title of Senate Bill 242.
Senate Bill 242 by Senators Gonzalez and Pedersen, also Representatives Gonzalez, Gutierrez, and Woodrow, concerning the expansion of the allowable uses of the Housing Development Grant Fund in connection therewith, making an appropriation.
Majority Leader Escar.
How about now I move Senate Bill 242 on third reading, final passage.
Seeing no objection, we will, yes, that is a proper motion, but there is discussion. Representative Woodrow.
Thank you, Mr. Speaker. I move for permission to offer a third reading amendment. Highly technical, folks. Changes, makes clear the effective date and makes clear the fund that the money's going to.
Great. Do you want to share that so we can put it up on the screen? Is there any further discussion on permission? Seeing none, the question before us is to grant permission to offer a third reading amendment on Senate Bill 242. Mr. Gregorio, please open the machine and members please proceed to vote. Representative McLaughlin, how do you vote?
Yes.
Representative McLaughlin votes yes. Representative Tipper, how do you vote?
Yes.
Representative Tipper votes yes. Please close the machine. 41 aye votes, 23 no votes, and 1 excuse. Senate Bill, the permission is granted to offer a third reading amendment to Senate Bill 242. Assistant Majority Leader Gonzalez Gutierrez.
Thank you, Mr. Speaker. I move Amendment L11 and ask for an aye vote.
Seeing no further discussion, the question before us is the adoption of L11 to Senate Bill 242. Mr. Gregorio, please open the machine and members please proceed to vote. Representative McLaughlin, how do you vote?
Yes.
Representative McLaughlin votes yes. Representative Tipper, how do you vote?
Yes.
Representative Tipper votes yes. Please close the machine. With 41 aye votes, 23 no votes, and 1 excused, L11 is adopted to Senate Bill 242. Majority Leader Escar.
Thank you, Mr. Speaker. I move Senate Bill 242 as amended on third reading, final passage.
Question before us is the adoption of Senate Bill 242 as amended on third reading and final passage. See no further discussion. Mr. Gregorio, please open the machine and members please proceed to vote. Representative McLaughlin, how do you vote?
Yes.
Representative McLaughlin votes yes. Representative Tipper, how do you vote?
Yes.
Representative Tipper votes yes. Representative Gray. Please close the machine. With 42 aye votes, 22 no votes, and 1 excuse, Senate Bill 242 is adopted. Co-sponsors. Please close the machine. Mr. Gregorio, please read the title of Senate Bill 27.
Senate Bill 27 by Senators Pedersen and Danielson, also Representatives Gonzalez, Gutierrez, and Tipper, concerning emergency supplies for Colorado babies and families and in connection therewith, providing diapering essentials through the diaper distribution centers and making an appropriation.
Majority Leader Escar.
Thank you, Mr. Speaker. I move Senate Bill 27 on third reading, final passage.
Question before us is the adoption of Senate Bill 27 on third reading and final passage. See no further discussion. Mr. Gregorio, please open the machine and members please proceed to vote. Representative McLaughlin, how do you vote?
Yes.
Representative McLaughlin votes yes. Representative Tipper, how do you vote?
Yes.
Representative Tipper votes yes. Please close the machine. With 41 aye votes, 23 no votes, and 1 excuse, Senate Bill 27 is adopted. Co-sponsors. Representative McLaughlin, co-sponsor. Please close the machine. Mr. Gregorio, please read the title of Senate Bill 158.
Senate Bill 158 by Senators Danielson and Pedersen, also Representatives Tatone and Duran, concerning modifications to the Colorado Health Service Corps program administered by the Department of Public Health and Environment to expand the availability of geriatric care providers in shortage areas in the state and in connection therewith making an appropriation.
Majority Leader Escar.
Thank you, Mr. Speaker. I move Senate Bill 158 on third reading, final passage.
Question before us is the adoption of Senate Bill 158 on third reading and final passage. See no further discussion. Mr. Gregorio, please open the machine and members please proceed to vote. Representative McLaughlin, how do you vote?
Yes.
Representative McLaughlin votes yes. Representative Tipper, how do you vote?
Yes.
Representative Tipper votes yes. Representative Bockenfeld. Please close the machine. 54 aye votes, 10 no votes, and 1 excuse. Senate Bill 158 is adopted. Co-sponsors. Please close the machine. Mr. Gregorio, please read the title of Senate Bill 243.
Senate Bill 243 by Senator Moreno, also Representative McCluskey, concerning annual appropriations to the Department of Public Health and Environment.
Majority Leader Escar.
Thank you, Mr. Speaker. I move Senate Bill 243 on third reading, final passage.
Representative McCluskey.
Thank you, Mr. Speaker. I request permission for a third reading amendment.
As proper motion, we'll have it displayed. You want to explain why? Representative McCluskey.
Thank you, Mr. Speaker. This is an amendment because of the contingency with the new cash fund that's been established. We had to clarify the passage of that bill first. I ask for your support.
Is there any further discussion on permission? Seeing none, the question before us is to offer permission to offer a third reading amendment to Senate Bill 243. Mr. Gregorio, please open the machine and members please proceed to vote. Representative McLaughlin, how do you vote?
Yes.
Representative McLaughlin votes yes. Representative Tipper, how do you vote?
Yes.
Representative Tipper votes yes. Representative Ricks, Holtorf, Catlin. Please close the machine. With 43 aye votes, 21 no votes, and 1 excuse, permission is granted to offer a third reading amendment. Representative McCluskey.
Thank you, Mr. Speaker. I move L005 to Senate Bill 243.
Is there any further discussion? Seeing none, the question before us is the adoption of L005 to Senate Bill 243. Mr. Gregorio, please open the machine and members please proceed to vote. Representative McLaughlin, how do you vote?
Yes.
Representative McLaughlin votes yes. Representative Tipper, how do you vote?
Yes.
Representative Tipper votes yes. Please close the machine. With 42 aye votes, 22 no votes, and 1 excused, L005 is adopted to Senate Bill 243. Majority Leader Escar.
Thank you, Mr. Speaker. I move Senate Bill 243 as amended on third reading, final passage.
The question before us is the adoption of Senate Bill 243 as amended. Mr. Gregorio, please open the machine and members please proceed to vote. Representative McLaughlin, how do you vote?
Yes.
Representative McLaughlin votes yes. Representative Tipper, how do you vote?
Yes.
Representative Tipper votes yes. Mullican Gray. Please close the machine. With 41 aye votes, 23 no votes, and 1 excuse, Senate Bill 243 is adopted as amended. Co-sponsors. Please close the machine. Majority Leader Escar.
Thank you, Mr. Speaker. I move to proceed out of order to Senate Bill 32 on the bottom of page 3.
Seeing no objection, we'll proceed out of order for immediate consideration of Senate Bill 32. Mr. Gregorio, please read the title of Senate Bill 32.
Senate Bill 32 by Senator Donovan, also Representative Ortiz, concerning establishing a mobile veteran support unit grant program and in connection therewith making an appropriation.
Majority Leader Escar.
Thank you, Mr. Speaker. I move Senate Bill 32 on third reading, final passage.
The question before us is the adoption of Senate Bill 32 on third reading and final passage. Seeing no Representative Holtorf.
Thank you, Mr. Speaker. I do understand the intent of this bill, and I understand the intent of the bill sponsor moving forward with the best of intentions. But I will tell you, as a military leader for many years, as a commander at various levels, understanding the value of the Uniform Code of Military Justice, and also understanding what commanders do when they work with JAGs to try to get the best possible outcome for the discharging service member. I have strong reservations with regard to what this bill does, because it truly says if you get a dishonorable discharge, because it waives all discharge provisions, it says if you get a dishonorable discharge under this particular program, you still get rights. You still get consideration of veterans' rights. And in the most heinous situations in our service, and there are military prisons for a reason, because not everybody serves with honor and pride. For those of us that have been to Fort Leavenworth, for those of us that have done duty assignments in Fort Leavenworth, Kansas, and understand what that means, it gives many a moment of pause, because there are many heinous crimes that occur during military service. Now, I'm not going to belabor the point. I respect the sponsor. I respect his intentions sincerely. I know what he is trying to do. But I served in the Pacific Theater. I'm going to just give you one example. I could give you dozens, hundreds, unfortunately. But when a service member, and I won't mention the service, rapes a local national.
Representative Holtorf.
And they get, I'll go to the bill. I'm going to stop right there. Thank you for your leadership. And they get a dishonorable discharge after their referred criminal charges, and we have a JAG officer that can speak to that. Well, I'm not asking for that. I'm just wanting to make the point and promote my objection, because there are objectionable justifications. And I won't be able to vote yes on this. And I support so many things my colleague does, supporting veterans. But this one I cannot, because I know there's a dark side, which I've just referenced, and those individuals do not deserve the benefits that those who have served honorably, who have been discharged and served their country, the benefits that they deserve is very different from the previous example that I mentioned. Thank you, Mr. Speaker. I don't want to belabor the point. I just want to make the claim that I will not be able to support this. Even as a champion of veterans, I will not be able to support this bill because of that line of distinction that is real and cannot be overlooked. Thank you, Mr. Speaker. Thank you, esteemed colleagues, for your attention.
Thank you, Representative Holter. For Representative Ortiz.
Mr. Speaker, it's an honor to serve with you.
Honor to serve with you too, Representative Ortiz.
Members, I rise and urge an aye vote on this bill. No one's extending benefits to veterans. What we're doing here is offering services to a group of veterans that are at the end of their rope. I mean, to end up homeless and to end up without is not a place that any of us would like to be. And regardless of mistakes made in the past, in my personal values and beliefs, there's no throwaway humans. There are no throwaway humans out there. This is extending and connecting veterans that are the most marginalized and that are in the greatest need with services and resources that the state already provides. No one's granting new benefits for those that made their mistakes. That's not what this bill does. And this speaks from my personal values and the work that I've done in the veteran community. This isn't just about my good intentions. This is about the work that I've done in the veteran space and continuing to build on that work here in the legislature. So for all those reasons and more, I urge an aye vote.
Thank you, Representative Ortiz. Seeing no further discussion, the question before us is the adoption of Senate Bill 32 on third reading and final passage. Mr. Gregorio, please open the machine and members please proceed to vote. Representative McLaughlin, how do you vote?
Yes.
Representative McLaughlin votes yes. Representative Tipper, how do you vote?
Yes.
Representative Tipper votes yes. Please close the machine. With 44 aye votes, 20 no votes, and 1 excuse, Senate Bill 32 is adopted. Co-sponsors. Please close the machine. Majority Leader Escar.
Thank you, Mr. Speaker. I move to proceed out of order for Senate Bill 103.
Seeing no objection, we'll proceed out of order for immediate consideration of Senate Bill 103, which is on the top of page 4. Mr. Gregorio, please read the title of Senate Bill 103.
Senate Bill 103 by Senators Fenberg and Winter, also Representative Escar, concerning the continuation of the Office of Consumer Counsel and in connection therewith implementing the recommendations contained in the 2020 Census Report by the Department of Regulatory Agencies regarding the Office of Consumer Counsel and the Utility Consumers Board and making an appropriation.
Nice job, Mr. Gregorio. Majority Leader Escar.
Thank you, Mr. Speaker. I move Senate Bill 103 on third reading, final passage.
Question.
And I need to ask permission for a third reading amendment.
Majority Leader Escar. We'll have it displayed and then please explain why.
Members, forgive me. Apologize. There was a simple drafting error in one of the amendments that we had already put on. We asked specifically to change this wording, and it got missed, and so now we're correcting it. Appreciate an aye vote, I would appreciate your permission.
Is there any further discussion on the motion to grant permission to offer a third reading amendment? Seeing none, Mr. Gregorio, please open the machine and members please proceed to vote. Representative McLaughlin, how do you vote?
Yes.
Representative McLaughlin votes yes. Representative Tipper, how do you vote?
Yes.
Representative Tipper votes yes. Please close the machine. With 42 aye votes, 22 no votes, and 1 excuse, permission is granted. Majority Leader Escar.
Thank you, Mr. Speaker. I move Amendment L018 to Senate Bill 103 and ask for a yes vote.
Has been properly moved and displayed. Seeing no further discussion, the question before us is the adoption of L18 to Senate Bill 103. Mr. Gregorio, please open the machine and members please proceed to vote. Representative McLaughlin, how do you vote?
Yes.
Representative McLaughlin votes yes. Representative Tipper, how do you vote?
Yes.
Representative Tipper votes yes. Please close the machine. With 41 aye votes, 23 no votes, and 1 excused, L18 is adopted as Senate Bill 103. Majority Leader Escar.
Thank you, Mr. Speaker. I move Senate Bill 103 as amended on third reading, final passage. I want to say hi to that cute little baby on the screen.
Seeing no objection, the motion before us is the adoption of Senate Bill 103 as amended on third reading and final passage. Mr. Gregorio, please open the machine and members, please proceed to vote. Representative McLaughlin, how do you vote?
Yes.
Representative McLaughlin votes yes. Representative Tipper, how do you vote?
Yes.
Representative Tipper votes yes. Please close the machine. With 41 aye votes, 23 no votes, and 1 excuse, Senate Bill 103 is adopted as amended. Co-sponsors. Please close the machine. Majority Leader Escar.
Thank you, Mr. Speaker. I move that we stand in a brief recess while Appropriations Committee meets. Members, once again, please do not go far. Should not take long. We will be back to finish all of the other work we have to do today.
Seeing no objection, the House will stand in recess until appropriations concludes. House will come back to order. Mr. Gregorio, reports of committees of reference.
Committee on Appropriations, after consideration of the merits, the committee recommends following: Senate Bill 137 be amended as follows, be so amended and be referred to the committee of the whole with favorable recommendation. Senate Bill 240 be amended as follows, be so amended and be referred to the committee of the whole with favorable recommendation. Senate Bill 264 be amended as follows, and be so amended and be referred to the committee of the whole with favorable recommendation.
Conference committee reports. Conference committee reports will be printed in the journal. Majority Leader Escar.
Thank you, Mr. Speaker. I move to proceed out of order for special orders.
Seeing no objection, we'll proceed out of order for immediate consideration of special orders, second reading of bills. Majority Leader Escar.
Thank you, Mr. Speaker. I move the following bills be made special orders today, Monday, June 7th at 11:14 a.m. Senate Bill 271, Senate Bill 88, Senate Bill 137, Senate Bill 40, and Senate Bill 264. Sorry. Senate Bill 240, not 140.
Seeing no objection, the bills laid out by the Majority Leader will be made special orders on Monday, June 7th at 11:14 a.m. Representative Kipp. Members, you have heard the motion. Seeing no objection, Representative Kipp will take the chair.
The committee will come to order. With your unanimous consent, the bills will be read by title unless there is a request for reading a bill at length. Committee reports are printed and in your bill folders. Floor amendments and will be shown in the screen and on your iPads. Bills will be laid over upon motion of the Majority Leader, and the coat rule is way relaxed. Okay. Mr. Gregorio, could you please read the title of SB 21-271?
Senate Bill 271 by Senators Gonzalez and Gardner, also Representative Roberts, concerning the adoption of the 2021 recommendations of the Colorado Criminal and Juvenile Justice Commission regarding sentences for offenses and in connection therewith, making an appropriation.
Thank you. Representative Roberts.
Thank you, Madam Chair. I move Senate Bill 271. There are no committee reports.
Thank you. To the bill.
Thank you, Madam Chair. Senate Bill 271 is the Commission on Criminal and Juvenile Justice recommendation for misdemeanor reform. This is an incredibly stakeholder bill by members of all sides of the criminal justice conversation. You can see the magnitude of this bill, but what this bill does is modernizes our misdemeanor laws, and it has input and support from all sides of the conversation, like I said, from prosecutors to defense attorneys to criminal justice advocates and everyone in between. And I would just want to thank the CCJJ for their incredible work on this, modernizing our criminal justice laws and streamlining our misdemeanor laws will make it easier for everybody in this conversation to administer justice across the state, to get justice for victims, to ensure defendants are held accountable, but also have clarity in our criminal justice laws. Thank you to the members of this chamber who are on CCJJ and to everybody who put their work into this bill, including the bill drafter particularly. This bill passed unanimously out of the Senate. I ask for an aye vote.
Thank you. Representative Woog.
Thank you, Madam Chair. So I'd like to recognize the work the sponsor and CCJJ have done on Senate Bill 271. Unfortunately, there is a change in the bill that may do more harm than good. The bill reduces the penalty for removing an 811 locate from a Class 2 misdemeanor to a petty offense. Currently, Class 2 misdemeanor, up to 12 months jail and up to a $1,000 fine. and it will become, if passed, a petty offense up to 10 days jail and a $300 fine. So, of course, that change without input from the pipeline safety community is an issue, and Colorado is already at risk of losing federal funding for our state pipeline safety programs due to other legislation. So with that, I move L009 and ask it to be displayed.
Thank you. The bill has been moved, or the amendment L009 has been moved and properly displayed. To the bill, or to the amendment, I'm sorry, Representative Woog.
So yeah, no further discussion. This really can cause some issues, and obviously removing an 811 locate is a pretty major thing. So I ask for a yes on this amendment. Thank you.
Representative Roberts.
Thank you, Madam Chair. Respectfully, I'm going to ask for a no vote on this amendment. We did hear some testimony about this in committee. What we also heard is that there has been one charge under this statute in the most recent year that there was data for that. This almost never happens, and so we believe reclassifying this to a petty offense with the input of the entire CCJJ is the right thing to do. So I respectfully ask for a no vote on the amendment.
Is there any further discussion on L009? Seeing none, the question before us is the passage of L009. All those in favor say aye. Aye. All opposed say no. No. The amendment is lost. To the bill. Any further discussion? Representative Carver.
Thank you, Madam Chair. I was a no in committee. While the bulk of the bill, which is quite lengthy and goes through more than 1,000 misdemeanors that are currently in our statute books, while I agree with much of what is in the bill, there are some of the offenses which I don't agree with the reducing the misdemeanor level, and there are individual DAs, that would be up to you to check with your DA, who have issues with the bill, but do want to commend the huge work of CCJJ and the really thousands of hours that went into this effort. And again, while I agree with the bulk of it, some reservations about parts of it, and that's why I was a no vote. Thank you.
Thank you. Representative Roberts.
Thank you, Madam Chair, and thank you, Representative Carver, for your work on the CCJJ, and Representative Gonzalez-Gutierrez. The District Attorney's Council is in support of this bill. 21 out of 22 DAs have taken a position of support. The lone DA abstained from the vote. So 21 out of 22 DAs support, and the organization as a whole supports the bill.
Thank you. Is there any further discussion? Seeing none, the question before us is the passage of Senate Bill 21-271. All those in favor say yes. Or aye, or yes, I'm sorry. And those opposed say no? The ayes and yeses have it. So the SB 21-271 is adopted. Mr. Gregorio, could you please read the title of SB 21-088?
Senate Bill 88 by Senators Danielson and Fields, also Representative Michelson, Janae, and Soper, concerning establishing a civil cause of action for sexual misconduct against a minor and in connection therewith making an appropriation.
Perfect. Representative Michelson, Janae.
Thank you, Madam Chair. I move Senate Bill 88 and the Judiciary Committee report.
Thank you. To the Judiciary report.
We have an amendment to the Judiciary report that I would like to, I move Amendment L74 to Senate Bill 88.
Oh, it is already displayed. So it has been moved and properly displayed. Would you like to explain your amendment, Representative Soper?
Thank you, Madam Chair. So our amendment here does a couple of things. It creates a soft cap of $500,000. And then upon showing of clear and convincing evidence, and if the jury determines that the award should exceed that, can go up to a hard cap of $1 million per instance of cover-up of child rape and sexual molestation. This came out of our stakeholding and is agreed upon, and hope the membership would vote yes. Thank you.
Thank you. Is there any further discussion on L074? Seeing none, the question before us is the adoption of L074 to SB 088. All those in favor say aye.
Aye.
All those opposed say no. The ayes have it. SB 788 and L074 is adopted. To the bill.
Nope, to the committee report.
What?
To the committee report?
Oh, sorry, to the committee report. Rep. Michelson Janae.
Thank you, Madam Chair. First, I want to give incredible thanks again to Representative Soper for being on this bill with me. This is a very complicated and a very heavy bill, and a lot happened in the committee work. So I'll talk about the bill now and then hand it over to Representative Soper to legalize you all. So what we have here in Senate Bill 88 is an opportunity for youth who have been sexually abused to be able to hold an organization who covered up, who they can prove should have known, covered up their sexual abuse and didn't provide them the help and the supports that they need. There were many, many hours. We're coming up on over a year of stakeholdering on this bill to get us to a point where we believe that we can give victims of child sexual abuse an opportunity to make themselves whole. For many of our victims of child sexual abuse, they don't come forward until they're well into middle age, because it is hard to be able to come to terms with what happened to you and how you were violated as a child. So this is an opportunity to have the time to come whole and hold the organizations who covered up your abuse accountable.
Representative Soper.
Thank you, Madam Chair, and thank you, Representative Michelson Janae. I've appreciated working on this bill with you. So to just walk you through what this bill actually does, Senate Bill 88 is the companion bill to Senate Bill 73, which this body passed earlier this year and was signed into law by the governor, which abolished the statute of limitations for rape and sexual assault. Senate Bill 88 creates a new civil cause of action that holds the organization liable for the organization's own conduct in knowing or should have knowing that a potential actor within their organization raped or sexually assaulted a child engaged in a youth activity. We added a couple of amendments in judiciary, so from 1960 to 1922, that victim will have a 3-year window to bring their claim that will expire.
1960 to 2022.
Sorry, 1960 to 2022. And those victims will have a 3-year window to bring their claim once this bill passes for the cover-up. I want to emphasize the cover-up of the rape or sexual assault of that child. And then going forward, after 2022, it's no longer a window. It's still that cause of action that's going to be out there. This is something that we definitely have felt strongly about, that organizations who cover up actually cut short a victim's ability to ever be able to bring a cause under any other legal theory, because the organization hid the smoking gun evidence. They suppressed the knowledge. They didn't talk to law enforcement. Instead, they may have transferred the perpetrator from one parish to another parish, from one school to another school, and that has just a chilling effect on the ability to see justice. Many people have asked, why go back to 1960? Well, what we learned from the Attorney General's report and what we've learned from victim after victim is that 53 is the average age that a child sexual assault victim is able to tell their story. And what we've heard from victims is that more important than money, they want to be able to make their case in court, to be able to tell their story, and to get their story out about some heinous crimes that happened to them. And that's what we're advancing here, is a new cause of action that will give some justice to some victims who are long overdue. I would ask for a yes vote. Thank you.
Thank you. So the question before, I'm sorry. Representative Geithner, we are still on the judiciary report. Is this to the judiciary report? Great. Minority Leader, or Assistant Minority Leader Geithner.
Thank you, Madam Chair. Members, this is one of those bills that I've taken quite a bit of time with to follow. It's been in judiciary here a couple times. I think it was laid over a couple times. Amendments were added. Senate did quite a bit of work. And there was quite a bit of discussion and argument, debate over the bill. And I certainly see the merits in it. Absolutely. But there's one provision of the bill, as it was last amended in judiciary, that has given me a lot of concern. The Senate actually attempted to try and address this, and they did successfully. Unfortunately, one of the amendments that was put on in the Senate was pulled off in House Judiciary. The bill talks about, and I don't know that I have my committee report here, about the limits for both the public and the private sector. And we say private sector, we naturally probably think of maybe like a private school, maybe a church, maybe a private organization, a camp. But when we talk of the public sector, what we're really talking about is we're talking about government. We're talking about public schools. We're talking about the public area. And as the bill currently reads, the public sector seems to get a pass. Because you see, the damages that a victim can go after, and what is arguably the most heinous of acts that any human can perpetrate upon a child, are limited. Under the bill as it currently reads, there is a protection specifically carved out for government entities that are funded by the taxpayer. The private sector does not have that same level of protection, which seems to me to say that if you're a victim, the victimization is treated differently between the private and the public area. And so what I'd like to do is I'd like to move L072, or I do move L072. I ask for it to be displayed, and then maybe we can have a little bit more discussion and debate.
Okay, L072 has been moved and is properly displayed. Assistant Minority Leader Geithner, please tell us about your amendment.
Thank you, Madam Chair. And I've phoned a friend. I'm working on getting a copy of the committee report, which has the limits, so I can speak to them very smartly. But if you remember, members, what we just did is we just adopted L074. L074 says if you're a private entity, your caps are at $500,000, and then it can go up to $1 million, but no more. As far as it is with the public organizations, those governments, so just think of like a public school, which there is case after case related to the incidences here in Colorado, in and around public schools specifically. And what L74 says is that the government should be treated the exact same way as the public or as the private sector. Meaning that the government doesn't get to sit back and say that they get a little bit of a pass. Meaning that if there is a victim who becomes a victim at the hands of a public employee, they are treated, and the trauma that they went through is valued in the exact same way as if it was a private organization. It sets the cap for, thank you. It sets the cap, which is currently at $387,000 in the public sector, and makes it tied to the exact same, which is the $500,000 for the private sector. You know, I have 2 kids, and I know of constituents in my district who have kids, and we look at our public spaces, whether there are public schools or other entities, and we say, we demand and we require the same level of safety for our children as we would in the private sector. And that's the purpose of what L72 is getting at. It's saying that the private sector, while there is the ability to go after relief at $500,000 or $1 million, that the public sector should be held to the exact same standard. That the victim is treated equally. That the victim's trauma is not valued less in the public space, but that it is valued at the exact same level in the public space. That's what L72 to L072 does. I suspect we're going to have a little bit of discussion on L072. I would ask for a yes vote on L072, and let's treat our public sector, our local governments, whether they be public schools or other, exactly the same way as we treat our private sector, because at the end of the day, the victimization of a child does not look differently if it happens in a public school versus a private school. The trauma is enduring and the trauma lasts, and L074 says we're going to honor that victim in the exact same way and not give a pass to the government.
Representative Michelson Janae.
Thank you, Madam Chair. Actually, we worked exceptionally hard on this cap section, and what we did do was increase the governmental immunity cap, decrease the private sector cap, so that we got closer to parity. Did we get exactly to parity? No, we did not. But we are looking at responsibly spending taxpayers' dollars. So yes, we believe the victims should be are equally as violated, and yes, we have worked very hard on making these caps fair, and we believe we've struck an unbelievable balance, and we ask for an aye vote, or excuse me, no vote on the amendment.
Representative Soper, I'll put you next after Representative Wiseman and Representative Holtorf.
Thank you, Madam Chair, and I appreciate the amendment. Thank you, Assistant Minority Leader Geithner. This is very difficult. I would love to see it on one hand, but on the other hand, it's just very difficult given the fact that we have a negotiated approach, and so that's why we're going to have to ask for a no vote.
Representative Wiseman.
Thank you, Madam Chair. I do join the sponsors in urging a no vote on this amendment. And what I want to point out is that what we're talking about here is actually something that is considerably older than this country. It goes back to the common law courts of the King and the Queen of England when it was called sovereign immunity. It was the idea that you could not sue the sovereign in his or her own courts. Now, we are not a country of a sovereign. We are a country of laws and a government of men and women who follow those laws. So we call it government immunity and not sovereign immunity, but the roots are there. Until about 1971 or so, or 72, in Colorado we had common law immunity, and the questions of waivers of liability and caps were set that way. In the early 70s, there was a trio of cases in which our Supreme Court abrogated the doctrine of common law sovereign immunity and stayed the effect of those cases, I believe, until 72, a year later, and so that this institution could set forth a statutory framework governing all of this that we're talking about now. 1972, that's older than some of us in this room. It goes back that far and farther than that. That's what gives us CJA now, the framework that is amended repeatedly. And you know, Mr. Assistant Minority Leader, you are pointing out an imbalance or perhaps an inequity. And you're not entirely wrong. This is what the law says, 2410-102, Declaration of Policy. It is recognized by the General Assembly that the doctrine of sovereign immunity, where under the state and its political subdivisions are often immune from suit for injury suffered by private persons, is in some instances an inequitable doctrine. The General Assembly also recognizes that the Supreme Court has abrogated the doctrine of sovereign immunity effective July 1, 1972, that thereafter the doctrine shall be recognized only to such extent as may be provided by statute. So that's what brings us to where we are now. So if there is an imbalance, if there is an inequity, it is not a matter of this bill. It is a matter of what has been the law of this state for at least decades and probably going back to statehood. And not just for matters of childhood sexual abuse like this, slip and fall, like anything that's a tort type of action. So the reason that I believe the sponsors are asking for a no vote, the reason that I am urging a no vote, is that we should not hold survivors of childhood sexual abuse hostage through this kind of amendment debate on this one bill when the real issue is as big as all of law. Where there is an imbalance, where we think that the government immunity cap is too low, where we think that there should be exceptions, let's have that debate in another way. Years ago, before either of our time, there was, I think it was a controlled burn that got very badly out of control down your way, down in El Paso County. And this General Assembly acted to recognize that harm and, created some kind of exception through a whole debate, through a whole bill, through a whole process that was not pushing something else over sideways, that was not going to have collateral damage in the form of jeopardizing this bill, which has been worked on all session. Members, this is maybe day 119 or effectively 119 or whatever. Senate Bill 88. Consider how low that number is relative to where we are now. Consider what it means that we're debating a bill with that low of a number this late in the game. It means some work has been done. It means there has been a challenging process to get to this point. Do not jeopardize that challenging process. Is there a debate to be had about CGIA? Oh, maybe yes. Let's have that debate another way. Let's not do harm to this legislation. Let's not hold hostage those that this legislation seeks to help by providing a remedy, by doing this here now. Because it will jeopardize the course of this legislation, I tell you that. Not sure there's another person in this legislature who's followed this bill more, other than the sponsors, who's followed this bill more closely than I have. I do agree with you, sir, on one point. The harm that a survivor has suffered is the same. The pain is the same. The wrong is the same. And I think it's important that we, standing here, acknowledge that. But this is decades old. This is centuries old. We need to resolve that another way, not here, not now, for the sake of survivors who are expecting us to pass this legislation. So acknowledging that there are debates here to be had, I do ask for a no vote on this amendment at this time.
Thank you, Assistant Minority Leader Geithner.
Thank you, Madam Chair, and thank you, Representative Weissman. I understand the gravity of what the amendment does. But I guess the challenge that I would have before this body is the only reason that this piece of policy is in jeopardy is if we don't act on this particular amendment and vote it in. And I say that because the Senate did it. It came to the House with this exact same provision on it. The bill was not in jeopardy in the Senate. It was taken off in the House Judiciary Committee. So the bill has every chance of success if we here have the courage to adopt L072. L072. And so I would urge a yes vote. I know I have other colleagues that are looking to have some comments and some time here in the well, but I did want to answer that one critical piece about the statements made around this piece of policy possibly being in jeopardy as a result of this amendment. I will reiterate, the trauma that any victim endures is the exact same whether it is in the public space or the private space, and we should treat them each with parity. We should honor those victims to be able to seek restitution with parity. We should not say that this victim is deserving of this level of compensation or relief, but this victim who may have had the exact same experience or possibly even worse should be treated less. I urge for you to adopt L072.
Representative Rich.
Thank you, Madam Chair, and I appreciate the words from Assistant Minority Leader Geithner. I was going to say something very similar to that because this bill did come over from the Senate with this amendment on there. And there's no better time than right now to have that debate because you put this back on there, there might even be some bipartisan support. It's important that every victim be treated the same, whether, like he said, whether they're in the public space or the private space. And to separate those two out, that's not right, and that's not fair to the victims. I urge an aye vote on this amendment.
Representative Van Winkle.
Thank you, Madam Chair. And first of all, it's absurd to say that the sponsors of this amendment are the ones that are rocking the boat when this is a Senate bill that came to us with this amendment essentially in it. I urge a yes vote on it because this amendment says that a victim of sexual abuse, and not any victim of sexual abuse, a child victim of sexual abuse, ought to be treated equally wherever they are abused. And that may have been the rule in the law of yesteryear, that if a child is sexually abused at school or something, that child is treated less judicially than a child that is abused outside of the schoolhouse. But it is shameful that we would say that a victim is less valued if they're sexually abused if it's by someone on the government payroll. Government employees are often employees that are in a position of trust and thus should at least be treated just as harshly as someone that would abuse a child, whether they're in a schoolhouse or outside the schoolhouse. To say that government employee in a position of trust shouldn't have to face the same consequences, or that the victim rather should not be compensated equally, is absurd and frankly shameful. I hope that we support this amendment and move this bill back to the way it came to the House to begin with.
Representative Holtorf.
Thank you, Madam Chair. To the bill sponsors, I appreciate your work. There is nothing more precious than the lives of our children, which should be protected. They do not need to be exposed to physical abuse, sexual abuse, or any type of abuse that can harm them. As a country boy from eastern Colorado, I'm not going to sit here and try to synthesize or analyze the legal jargon, because frankly, we make laws and change laws in this chamber when there is things that are wrong and there is disparity. So all the side talk, up talk, down talk, legal talk doesn't matter. In this particular situation, we're talking about the lives of our children and our youth. Now, I don't know what backdoor deals were made when this came from the Senate and walked into the House. I've heard some rumors. They wanted this in there, and then it got stripped out. I will tell you, House Chamber and colleagues, we need to stand stronger. We need to say the children come first, and special interests and public lobby can get out of the way. Because people come before policy, and people come before special interests, and people come before your dirty little secrets that you're trying to protect or defend.
Representative Holtorf, can you please be careful about impugning the motives of the bill sponsors or any others who might have worked on this bill?
I will be careful, but I don't know what's going to happen, because I think we need to tell Colorado what's going on here. They need to know the truth.
Representative Holtorf, so long as you can make your point without impugning others' motives, that's fine.
And ma'am, I appreciate your leadership. I will do my best. If any time I get out of line, I want you to prompt me and correct me, please. But I will tell you There are special interests that are protecting the public places and the public spaces that are involved in this heinous crime. They're in our cities. They're in rural Colorado, and they should not be tolerated, and there should be parity. If something's going on in a school and the faculty and administration know about it, then you know what? They shouldn't get away with it. It's not okay, Colorado. Just because you're working for a public entity doesn't mean that you should have special consideration over a private entity. And that's what this amendment speaks to. Now, I know all the backdoor deals and the secret handshakes and all the secret messaging that goes on and how we want to protect this and that and the other because they support certain people and certain parties or whatever goes on. And I say, Colorado and representatives of this state, when do you got a belly full? When do you say no more? No más, basta ahora. I could say it in Spanish. Would you understand it if I said anything wrong? I think you would. And I won't. Trying to be a little lighthearted in a very, very difficult conversation. And I'm tired of tiptoeing around it. I know a lot of people here have family, kids and grandkids. And do you want your kids and grandkids exposed to that? And do you think that public spaces and public places should have less of a penalty than private ones? Well, absolutely not, Colorado, and I'm going to speak loud because y'all need to hear it. I'm telling you, the dirty little secrets we have to hide because things are going on and things are going wrong, but special interests are levering us and making us give them consideration that they don't deserve. Doing the same crime they'll do in a public place or private place deserves the same penalty as in a public space. And that's a fact, Jack. Now I'm going to have to step down. I'm getting a little excited, and I don't like to do that. But I will tell you, I think about my little granddaughter. My little granddaughter. She's going to grow up. And as all of us, we've got to go to a lot of different places, public and private. And when you have people that are in positions of trust, positions of authority, positions of great responsibility and restraint, and they start to become sexually deviant and do heinous and horrible things to children, it's not okay, Colorado. There's a special place for those kind of people. I won't mention it, but you can all figure it out. Now, why in the world? I know why. Because a special interest that doesn't want this amendment, because in their place, they've got a problem or interest. There might be 2 or 3 or 4 of them. I won't mention them because I don't want to impugn anybody. You don't have to think very hard to figure some of that out. They don't want this amendment because they want that special protection. And I understand at great compromise and debate, we've made a compromise. But to compromise the life experience of a child, in my humble opinion, is unacceptable. And I wouldn't do it. I wouldn't do it today, and I wouldn't do it for anybody. And they can take their special interest and their money and stick it.
Representative Pico.
Thank you, Madam Chair. I rise in support of this amendment. It puts public and private institutions on the same footing. But I want to talk a little bit to the principle that was talked about a few moments ago on sovereign immunity. As a local official, I've seen those protections systematically stripped away, item after item, at the local level. What this amendment does is ensures that we treat public and private institutions equally Without this amendment, we're writing into law a double standard. Sovereign immunity has a place, but it needs to be carefully limited. This bill, as it's written, imposes a double standard, and that's not something we should accept. I ask for an aye vote on the amendment.
Representative Weisman.
Thank you, Madam Chair. Again, I just want everybody to dwell on the fact that if we have different limits for public entities and other entities, that is not arising out of this bill. That is arising out of decades and centuries of statutory law and case law. That is what government immunity is about. I don't love everything about it either, probably none of us does. But it is what this bill inherited. It is what the sponsors of this bill inherited. It is what the advocates of this bill inherited. I think I just want to say two things in connection with that. Something that I have observed in years of judiciary and in years of observing this place and debate in this well is when people try to speak for victims or for survivors, frankly, without having spoken to them. If you want to speak for survivors of crimes, especially of this kind of crime, start by speaking to them and learning from them. Again, Senate Bill 88 was introduced early in session. It was introduced tracking existing law, meaning, yes, the government immunity cap applies against public entities and other things apply also. And it went through Senate Judiciary and it went through Senate Appropriations. And only by means of a committee of the whole amendment at that relatively late stage in the Senate did this change get made. So this concession to reality, if you will, was an affirmative choice made by the Senate sponsors of the bill and the proponents that they worked with for months. Did they love it? I bet they didn't. Did they feel that it was their best chance to proceed to passage, to provide some kind of remedy for some people of horrible abuses? Yes, they made that choice. And I'm here to say that that choice should be respected, that in the vein of listening to survivors, which I have for hours of painful testimony in the Judiciary Committee, and I wish some people here would go back and listen to that tape and understand this, I think that choice should be respected. I think this is about the last time and place where we should purport to substitute our judgment for the judgment of people who've actually lived these things, who've actually suffered these things, who've brought this bill to this place. So again, I'm here to ask for a no vote on this amendment.
Representative Soper.
Thank you, Madam Chair. I did just want to come and respond to a point that was made earlier. So there was a claim that if you're in public school, that under state law you wouldn't be able to, that you would still be able to seek a claim for damages, but it wouldn't be in parity. That actually is incorrect. So as it stands right now, a plaintiff cannot bring a state law claim against a school district under current law, but Senate Bill 88 changes that. And I think that's really important to remember, that if you're concerned with our public schools sheltering and harboring perpetrators who rape and molest our kids, groom our kids, you need to support Senate Bill 88. Because right now, our school districts are protected. And I do think that that is important. What my colleague from Aurora was saying is also very important to keep in mind, that in the history of our state, the CGIA has always cut short any tort reform that has gone on for limitations of non-economic damages in other areas. We actually achieved something very significant here, something that has never happened. We have a hard cap for damages. That's not even contemplated by the 1986 tort reform in Colorado, which is only for non-economic damages. What we have in the bill is actually a hard cap for economic, non-economic, and punitive damages. And I think it's just really important to remember how this operates, and that we have opened the door, opened the window, as it were, to give victims an opportunity to make their case in court. And we've also opened that window for victims at our public institutions, our state agencies, and our public schools to have a shot at justice. As it stands right now, if a state actor injures you in a car crash, you have a claim. If a state actor rapes a child, you don't automatically have to have a claim at all. And if the state covers that up, you have absolutely no claim. It's important to remember the bigger picture of what we're doing here, which is why I'm going to have to ask for a no vote once again on the amendment. But members, keep in mind that we are seeking justice with Senate Bill 88.
Representative Pico.
Thank you, Madam Chair. I want to respond to a couple of things. Again, without this amendment, we're writing a double standard into the law. And I want to emphasize something else. All of us care deeply about this subject. None of us want to see this sort of abuse go on and go unpunished. Comments were made a few moments ago that one person really feels more about this than others. I thought were condescending and insulting, and I don't expect to hear that kind of conversation here. Thank you.
Okay, is there any further discussion on L072? Seeing none, the question before us is the passage of L072 to the Judiciary Committee report for SB 21088. All in favor, please say aye. Aye. All opposed, please say no. No. Okay, the noes have it. The amendment is lost to the bill. Or to the Judiciary Committee report. Seeing no further discussion on the Judiciary Committee report, all in favor of the Judiciary Committee report, please say aye. Aye. All opposed, please say no. No. The Judiciary report passes. The ayes have it. Okay, now to the bill. Okay, I'm seeing no further discussion on the bill. The question before us is the passage of SB 21088. All in favor, please say aye. All opposed, please say no. Okay, the amendment passes. Thank you. Or the bill passes. Apologize. So SB 2188 is adopted. And I'll bang the gavel again just for good measure. Okay. Mr. Gregorio, could you please read the title of SB 137?
Senate Bill 137 by Senators Pedersen and Winter, also Representatives Michelson, Janae, and Kennedy, concerning the Behavioral Health Recovery Act of 2021 and in connection therewith, making an appropriation.
Representative Kennedy.
Thank you, Madam Chair. I move Senate Bill 137, the Appropriations Committee report, and the Public and Behavioral Health and Human Services Committee report.
Thank you. To the Appropriations report.
Thank you, Madam Chair. In the Appropriations Committee, not only did we add the appropriations clauses for the various different programs that we're funding with this bill, but we also made one change that was a substantive change where we worked out an agreement between the Department of Human Services and Children's Hospital about adding some funding for residential beds for foster kids. We ask for an aye vote.
Thank you. Is there any further discussion on the appropriations report? Representative Pelton.
Thank you, Madam Chair. You know, there's a lot of good in this bill. There is one thing that I do not like, though, and that is the Clean Syringe program. So with that, I move L063 and ask that it be displayed.
Wait, stop. Is that an amendment to the Appropriations Committee report? Okay.
You're right. Sure enough. Okay.
Thank you. The amendment has been moved and is properly displayed. Can you please tell us about your amendment, Representative Pelton?
This amendment is real simple. It just it takes the funding away from the Clean Syringe program, takes the Clean Syringe program away from the bill, and saves $2 million taxpayer dollars. So with that, I urge a yes vote on 063.
Thank you, Representative Kennedy.
Thank you, Madam Chair. I appreciate the sponsor's concerns and what he's expressed here, but I'm going to ask for a no vote on this amendment. We believe that there's really strong evidence suggesting that needle exchange programs not only prevent the spread of diseases and help help people who are struggling before they get to the point where they're ready to ask for help, but it also puts them in direct contact with the folks who are going to be the ones who help them access those resources when they're ready to try to get sober and ask for help. So please vote no on this amendment.
Thank you. So seeing no further discussion, any further discussion on L063? Seeing none, the question before us is the passage of L063. All in favor, please say aye. Aye. All opposed, please say no. No. Okay, the L063 is lost. To the committee report, Assistant Minority Leader Geithner.
Thank you, Madam Chair. Members, I just wanted to come up and I wanted to thank the sponsors. I know that they did some work in appropriations, specifically around a $5 million appropriation for beds for kids. Specifically, it was explained to us in committee, because I had the privilege of sitting in on this one, that talked about the idea of the most acute cases of our kids, those that had maybe even attempted suicide or otherwise, would then be stabilized, but then had a little option as where to go in that step-down space. So there was a $5 million appropriation that I believe was added to the bill in appropriations. I think that was J005 and L066. Just wanted to say thank you to the sponsors for those amendments. I think that money will allow families access to some services that I feel like these families very much need. And I just wanted to come up and give you my thanks and my gratitude.
Thank you. Is there any further discussion on the Appropriations Committee report? Representative McCluskey.
Thank you, Madam Chair. And I, too, want to add my gratitude to CCAT and CCI for coming together, working with Children's Hospital. On the Western Slope, Children's Hospital is our primary source for services and care when children are in crisis. And I was very pleased to see this intensive work between stakeholders coming together in kind of the final hours of our session to do what was right by our kids. So I'm very grateful to all who participated and appreciate the bill sponsors' work on this front as well.
Thank you. Is there any further discussion on the Appropriations Committee report? Seeing none, the question is the adoption of the Appropriations Committee report for SB 21-137. All in favor, please say aye. Aye. All opposed, no. Okay, the ayes have it. The Appropriations Committee report is adopted. To the Public and Behavioral Health and Human Services report, Representative Kennedy.
Thank you, Madam Chair. I move Amendment L68 to the committee report and ask that it be displayed.
Thank you. The amendment has been moved and is properly displayed. Please tell us about your amendment, Representative Kennedy.
Thank you, Madam Chair. Members, this is a technical correction that our drafter caught after the previous amendments were made in the committee. This just makes sure the section numbering is correct. We ask for an aye vote.
Thank you. Is there any further discussion on L068? Seeing none, the question before us is the passage of L068 to SB 137, it's committee report to Public Behavioral Health and Human Services. All in favor, please say aye.
Aye.
All opposed, no? Okay, the committee report is adopted. The ayes have it. Or not the committee, the amendment to the committee report is adopted. Okay, now to the committee report for Public Health and Behavioral Health and Human Services. Representative Amabile, man, it has been a long session.
Thank you, Madam Chair. So I just wanted to get up here and say that I'm really very grateful to the sponsors of this bill. I know that it's been a big lift, and I know that we all, on both sides of the aisle in this chamber, have talked a lot about mental health this session and about how much we care about getting people the resources they need who are suffering with mental illnesses. And this bill really moves us big time in that direction, and I'm very grateful for that. And the one amendment that I asked for, I got, and it is in the bill, and it's really important because it allocates some funding to jail-based behavioral health services. And the jails in Colorado are the single biggest providers of mental health care. And they need help doing the best job that they can do until we figure out a way to stop sending people with mental health problems to jail. And we're going to work on that too. But in the meantime, this is really a positive step, and I'm very excited about it. So I urge you all to vote yes. Thank you.
Thank you very much. Is there any further discussion on the committee report? Okay, Representative Kennedy.
Thank you, Madam Chair. I just wanted to take a moment to speak about the committee report because I know there has been some discussion that we have sometimes glossed over what was done in the committee. We actually did really significant work in the committee, not only continuing some of the stakeholding work that was started when the bill was in the Senate, but also in committee we made the decision that this bill was going to be the vehicle for about $100 million in investment in behavioral health services, largely for emergency needs, but also getting the ball rolling on some major system reforms that we believe are going to be a huge step in the right direction. So we're excited about what this bill is doing as amended by the committee, and we ask for your support.
Thank you. Is there any further discussion on the committee report? Okay, seeing none, the question before us is the adoption of the Public and Behavioral Health and Human Services Report to SB 21-137. All in favor, please say aye.
Aye.
All opposed, no? Okay, the ayes have it. The committee report for Public and Behavioral Health and Human Services to SB 21-137 is adopted. To the bill. Representative Kennedy.
Thank you, Madam Chair. I move Amendment L67 and ask that it be displayed.
Okay, the L067 has been properly moved and is displayed. Can you please tell us about your amendment?
Thank you, Madam Chair. Members, this is another technical amendment. Part of what we're doing with the bills that spend some of the new federal money is we need to make sure that they spend money after it has been transferred into the appropriate cash fund in the state. So that is why this bill is now saying that all the sections go into effect one day after Senate Bill 288 goes into effect, which is the one that transfers the money into the right cash fund. We ask for your support.
Thank you. Is there any further discussion on the amendment? Seeing none, the question before us is the passage of L067 to SB 137. All in favor, please say aye.
Aye.
All opposed? Nay? Okay, well, I think the ayes clearly have it. The L067 is adopted. To the bill. Representative Michelson-Jeannet.
Thank you, Madam Chair, and thank you so much to my amazing co-prime, Representative Kennedy, for all of the incredible work on this bill. This bill has been stakeholdered for a really long time. And ultimately, what we were attempting to do in this bill and what we see that we have put forward in front of you is an opportunity to shore up our behavioral health system after the impact of COVID. We have seen a very significant behavioral health crisis during COVID. We asked people to lock themselves in their houses and protect themselves. And for many people, that was being locked away with their alcohol or with their paraphernalia or with their own demons. And they weren't able to get the appropriate support they needed in the way that they needed it. And our behavioral health system stepped up like no other. But what that means is that we had people who were working 24-hour days. We had people who were working to help shore up our community. We had people who were in the helper role that never stopped. So this bill, as you see it, covers a wide range of our system and puts it back into place so that we can continue to support our community right now in the way we need. I ask for an aye vote.
Thank you. Is there any further discussion on Senate Bill 137? Seeing none, the question before us is the adoption of Senate Bill 137 as amended. All those in favor say aye.
Aye.
All those opposed, no. The ayes have it. Senate Bill 137 as amended is passed. Mr. Gregorio, please read the title of Senate Bill 240.
Senate Bill 240 by Senators Danielson and Simpson, also Representatives Kipp and Catlin, concerning the transfer of money from the general fund to the Colorado Water Conservation Board Construction Fund for watershed protection grant programs and in connection therewith making an appropriation.
Representative Kipp.
Thank you, Mr. Chair. It's a pleasure to serve with you.
It's an honor to serve with you, Representative Kipp.
So I move SB 21-240 and the Appropriations Committee report.
Thank you. To the committee, Appropriations Committee report.
Well, I think I'm going to let my, sorry.
Representative Catlin.
Thank you, Mr. Chair. It's an honor to serve with you.
It's an honor to serve with you.
Well, evidently, I told a good enough joke there this morning that they added $10 million to the bill that I was carrying. And she made the motion. So it is a good idea. Here's the deal. What this bill is about is watershed restoration and watershed mitigation grant program. We had asked for 20 million because we didn't think, and DNR and all did not think that they might be able to deal with that amount of money any more than that. Since the bill was written and since we've gotten to this point, the state of Colorado assures us they can get these dollars out. This is something we can do for right now. I think all of you remember waking up to see the sun when it didn't look like you lived on Earth. You might have lived outer space somewhere because the sun looked like something you'd never seen before. This is an opportunity for the state of Colorado to do something that might help with that. And for those that have been destroyed, this is the money, this is the help that the state of Colorado is going to bring to them. I ask for a yes vote.
Thank you, Representative Kaplan. Representative Valdez.
Thank you, Mr. Chair. Are we still on the committee report?
We are.
Excellent. And I want to thank the bill sponsors for bringing this bill to the Ag Committee. This is a huge need needed, but also as we heard, adding in $10 million, I think we need to put a little bit more in that. Why? Because water is a big issue here in the state of Colorado as a headwater state. And water is especially needed now more than ever. Our snowpack was low this year, but we were moving forward. Hopefully, I thought we were going into a drought. And what a drought does not only to our soils, our land, but also our communities and our districts. And fortunately, we've got some much needed moisture. As I went home this weekend, I was amazed about the amount of moisture we received not only on Friday, but even yesterday. This bill not only helps the Colorado Water Conservation Board with projects moving forward, not only in my district, whether it be stream bank restoration or land conservation for our water. And you heard this morning about our sun, how important when the sun rises every single morning. We're drinking that cup of water, that freshing cup of water. Because in rural Colorado, where I come from, or a place I call home, water is our livelihood. Water is everything, whether it be to our community, to our agriculture community, but also to the people. And with that coming out of committee, this was a good bill moving forward. And yes, I wish we could add some more money to this every year, because education in water is huge. And I want to thank WECO. I want to thank the Colorado Water Conservation Board and all those involved in the Water Congress here today. So thank you to the bill sponsors, and this is a good bill coming out of committee, Senate Bill 240. Thank you.
Is there any further discussion? Representative Pico.
Thank you, Mr. Chair. I rise in support of this bill. It's a good bill. One of the issues that we've been very much concerned with in Colorado Springs utilities, because we have water projects and watersheds in 17 different counties across the state of Colorado. And this is a very key part of ensuring that we get that water. We have to maintain the health of the watersheds, and I urge an aye vote.
Thank you. Is there any further discussion on the Appropriations Committee report? Seeing none, the question before us is the adoption of the Appropriations Committee report. All those in favor say aye.
Aye.
Opposed, no. The Appropriations Committee report is passed. To the bill. Representative Kipp.
Thank you, and I do want to thank my co-prime sponsor here for allowing me to be on this bill with him after the departure of Jenny Arndt. So I kind of feel like I'm representing Jenny up here, but she certainly knew more about water issues than I did. But just let me tell you a little bit about this. This is a really wonderful bill because what it's going to work to do is provide critical funding to help restore our watersheds following the horrible, horrible fire season that we had last year. I don't know, in my part of the state, the skies were so strangely colored some days because of those fires. We thought it was, I think apocalyptic was the term everybody was using, and it just sort of came to mind as we were discussing what the skies looked like during those waters. But what happens during those fires is that a lot of stuff is burned and there's ash, and it harms our watersheds. It harms everything coming down. So what we need to do is put money into the watershed, mitigation of the damage that's happened to help them out. And one of the really great things about this bill is that we're actually pulling down federal dollars when we do this. And there's like a 3-to-1 match for federal dollars. So every additional dollar we put in, we're going to get additional money from the federal government, which is a great thing.
Any further discussion on Senate Bill 240? Representative Catlin.
Thank you, Mr. Chair. One of the things I wanted to talk about is that while we were presenting this bill in the Ag Committee, it came to the attention that the northern part of the state of Colorado has need for more than what this bill can even do. Yet this is still a statewide grant program. It's not identified for one specific part of the state, and that's one of the things that we made clear in the Ag Committee, is that this needed to be available statewide. And that's the way this program is going to be. So if you see activity in the watersheds or in the forest up above you, you might want to thank this grant. This is a good bill. Vote yes.
Representative Kipp.
And one more thing, the Water Board made very clear to us that if you want to get the grant, you have to apply for the grant. So if you're somewhere in the state and need a watershed grant, you will need to apply for it.
Thank you. Representative Valdez.
Thank you, Mr. Chair, and it's an honor to serve with you.
It's an honor to serve with you, sir.
You know, I want to thank the bill sponsors once again on Senate Bill 240 because this is exceptional, needed not only for the engineering, the design, review, analysis, but when you have a fire, it's detrimental. Detrimental to our water, our inflows, all the way in, whether it be to our streams and ditches. When you have a fire, not only does it burn everything in your path, but what it leaves behind. From the soil residue of the burn fire. And this bill helps not only put the planning, the analysis, how do we move forward from here, especially the last two fires we had last year, the Cameron Peak, the troublesome, and fires in the past, especially in House District 62 when we had the spring fire. That fire went through so fast we didn't even know it till the next day. I don't want to thank all those who were involved in that. But with this is a good bill. Not only continues to make sure education and priorities are moving forward, but projects for our communities and for the state. As once again I did mention, the headwater state of Colorado, not only for other states, but also to the country of Mexico. And this is exceptionally needed now more than ever. And absolutely, we could add more funding to this every single day and every single year. Because when is enough of putting projects as our huge priority, and water is our livelihood, and it is needed now more than ever. As the Front Range continues to grow, we need to make sure our water is protected in our communities. We need to live within our means and make sure that water is a huge asset, but also water is top priority. Thank you to the bill sponsors, and you have my support on Senate Bill 240. Thank you.
Thank you, Representative Valdez. Representative Will.
Thank you, Mr. Chair. It's an honor to serve with you.
It's an honor to serve with you.
I'll make this brief, but we heard this in committee. This is a great bill, and then now I understand they added $10 million to this. It's even a better bill. So this is really going to help, and I love that it's a statewide thing because it's really going to help my communities and my two in particular, but in my district, due to the fires, this is going to be a great thing. So strong support. Thank you.
Representative Pelton.
Thank you, Mr. Chair. I also heard this bill in the Ag Committee. You know, it was on the news within the past week with some of this rainfall that's been occurring. streams up in Boulder County had turned black. So we need to put this money out there, get these rehabilitation projects going to protect our reservoirs, keep the mud and the silt from coming in and taking away capacity of our reservoirs. So this is a very important bill, and I'd urge a yes vote.
Minority Leader McKean.
Thank you very much, Mr. Chair. I urge an aye vote, and part of my conversation this weekend was on a town hall with Congressman Neguse, and part of that discussion was what is about to happen in Grand Lake. And I don't think that this should be lost on people, that the effect of these forest fires is not just the fire and people losing their homes and the condition that's left behind that's very visible. It's also the fact that most of the soil that was affected by the East Troublesome Fire and the Cameron Peak Fire is now hydrophobic. And so it now doesn't absorb water, and that runoff is going to take a while to come down, but literally you will not have a clear Grand Lake for a while, and we know that. And we can deal with that, but we have to have these dollars available to those communities who depend not only on the water for drinking and water to send over to this side and water that's going to go down the main stem of the Colorado. We also have to have the ability to stabilize those slopes, to do everything we can in these critical months after a fire season like one we had. So this is an important aye vote. I'd like to see all green up there. This is something that we do for all of our communities together.
Is there any further discussion on Senate Bill 240? Seeing none, the question before us is the adoption of Senate Bill 240. All those in favor say aye. Aye. Opposed, no. The ayes have it. Senate Bill 240 is passed. Mr. Gregorio, please read the title to Senate Bill 264.
Senate Bill 264 by Senator Hansen, also Representatives Valdez and Burnett, concerning the adoption of programs by gas utilities to reduce greenhouse gas emissions.
Thank you. And Representative Valdez.
Thank you, Madam Chair. It's an honor to serve with you.
It's an honor to serve with you.
I move Senate Bill 264 and the Appropriations and Energy and Environment Committee reports.
Okay, to the Appropriations Committee report.
Well, we told some bad jokes and got some money and asked for an aye vote.
Okay, is there any further discussion on the Appropriations Committee report to 264? Okay, the question before us is the Appropriations Committee report to SB 21-264. All in favor of the committee report, please say aye. Aye. All opposed, no? Okay, well, the ayes clearly have it. The Appropriations Committee report is adopted. To the Energy and Environment report. Representative Valdez.
Thank you, Madam Chair. So we added a simple drafting fix that just corrected a citation. That was the only thing we did, and we'd ask for an aye vote.
Excellent. So any further discussion on the committee report for the Energy Environment? No. Okay. So the question before us is the adoption of the Energy Environment Committee report to SB 21-264. All in favor, please say aye. Aye. All opposed, no. Okay. The ayes clearly have it. The committee report to Energy Environment to 264 is adopted. To the bill, Representative Burnett.
Thank you, Madam Chair. Buildings are the fourth largest source of greenhouse gas emissions pollution in Colorado due to combusting gas used to heat buildings, heat water, and heat food in homes and businesses, as well as in power industrial processes. According to the Greenhouse Gas Reduction Roadmap, this sector needs to reduce greenhouse gas emissions by 25% by 2030. So a clean heat standard is critical to reducing emissions in this sector. This bill creates a clean heat standard with enforceable emission standards by requiring utilities to file with the PUC, the Public Utilities Commission, to reduce emissions by 4% by 2025 and 22% by 2030. It enables a new suite of innovative emission reduction technologies that natural gas utilities can use to reduce emissions. It also has a customer-centric focus by empowering the Public Utilities Commission to oversee utility compliance plans to maximize cost effectiveness, ensure opportunities of lower-income customers, and establish a regulatory framework for the role of gas utilities in a low-carbon future. For low-income and other disproportionately impacted communities, the PUC will ensure adequate environmental protection and encourage utilities to use skilled Colorado laborers. The benefits of this bill is it implements the key component of the greenhouse gas reduction roadmap, reduces emissions of greenhouse gas pollutions that drive climate change, improves indoor air quality, provides regulatory certainty for affected sources, is technology neutral, focuses on providing benefits to low-income residential customers, and creating good-paying jobs for Coloradans. And that's it. Thank you.
Representative Valdez.
Thank you, Madam Chair. And so this is a great bill that's going to create healthy air and reduce greenhouse gas emissions. Like my colleague said, it supports low-income residential customers. It's been worked out. The utility, the main utility here in the metro area and across the center of the state to the western slope, Xcel Energy, has already been doing some great things. This just helps them to get there a little bit quicker and help us to move along our greenhouse gas roadmap. So I'd ask for an aye vote.
Thank you. Representative Hanks. Yes, I know.
Thank you, Madam Chair. I just have a quick comment on this. Of course, I'm in opposition to it because I think it's a hoax. But what's also a hoax, let me tell you this. I'm getting a lot of feedback from people in my district. Had the opportunity to have a couple days to talk to them. What they do not want to hear anymore out of a body like this that is running a $34 billion budget is we went to appropriations, told a joke, got some money. That's a little flippant with people's cash. $34 billion. Let's treat the people of Colorado with some respect here.
Representative Pico.
Thank you, Madam Chair. I rise in opposition to this bill. I've got a couple of concerns. And first and foremost, what the bill does is something that we haven't seen in too many others. It's going to hold the utilities responsible for the actions of their customers. If the customers take advantage of all of the different demand-side management programs and put energy-saving devices in, great, that's to their advantage. But those who don't are going to see their rates increase. This bill has a cap on how much the utility is going to spend on that at 2.5%. That's good. Appreciate that. But you also got to realize that if the costs are going up 2.5%, their rates have to go up 2.5%. That's how utilities pay for everything that they do. It's a direct relationship. So if the costs go up, the rates go up. So who's paying for all those demand-side management programs are those who don't take advantage of them, and that's going to be a majority of people. Over time, an awful lot of people are going to take advantage of them, but that's a very fundamental piece of inequity. There's no fairness in that. There's no equity in that. And those of your constituents who don't upgrade, or who don't spend several $100s or more on an upgrade to a particular device that has a adequate Energy Star rating in order to pick up the bonus or the rebate, rather, are the ones who are going to be paying for that. That's not fair. And that's not fair to your constituents in your individual districts. The other concern that I have is this thing is centered on the whole issue. It's supposedly science-based. And I want to address that because it makes the assumption that this is all about fighting climate change, and that's fine. You want to fight climate change, you want to reduce your carbon emissions, you want to decarbonize, well, it should be your choice. But this bill mandates that performance and mandates it on the utilities. Again, mandating the utilities live up to target standards that they are entirely dependent upon their constituents, their customers, and picking up. But I want to address that bit of climate change because while climate does change, it goes up and down, it fluctuates tremendously, it depends upon which thing you want to talk about. The bill says it's science-based. Well, it depends on whose science you want to read. I've got that book on my desk, that thick. I can start reading chapters on it, but I'm not going to do that. I want to point out, though, that there's differences in how that's measured and how that is. And the vague claim of climate change fails to address any particular standard, any particular numbers that you'll say, okay, we've met that, we've accomplished it, or we have a ways to go. In science, in real science, you put a hypothesis out, and you wait and get the data back. And when you get the data, you either validate your hypothesis or you rewrite it. In every field of science except this one. And here in this bill, I'm proposing that we put some standards in there, whereas if the changes in the climate don't hit your concern, don't hit to the objective, that you stop and hold off. And to that, I move Amendment L015 and ask it to be displayed. I've run a variation of this before.
Representative Pico, hold on. The L015 has been moved and is properly displayed. So now you may please explain your amendment.
What this amendment does is it holds in abeyance the carrying out of this plan, delays it for a year, or second year, or third year, if the actual numbers that come in off the climate change reporting agencies don't hit a certain threshold. Right now, you've got a range of predictions on different climate models. The most extreme shows a 6-degree rise by the end of the century, 80 years away. That requires a 3/4 of a degree rise per average over each decade. The United Nations Intergovernmental Panel on Climate Change has a little less aggressive thing, but it's still pretty significant. What I propose here is that if that is the temperatures as measured by the satellite sensing unit and reported out to the University of Alabama is a 1/4 of a degree per decade or less, that you hold in abeyance this. Now this is a performance-based assessment. If what you are afraid of continues to happen, or happens at all, this particular amendment self-destructs. So have the courage of your convictions, put this in. Now, I haven't been before appropriations, haven't had the opportunity to tell any bad jokes over there, but if I tell a bad joke, can I get the amendment passed? No? Nice try, yeah.
Okay, thank you. Is there
That's
any
right.
further discussion on L015 to 264? Okay, seeing no further discussion, the question before us is L015 to 264. All in favor, please say aye. Aye. All opposed, no? No. The noes have it. The amendment is lost. Representative Pico.
Thank you, Madam Chair. Well, I got one more. This has, of course, the safety clause in it. And this is not something that necessarily needs to be in there. It's got a couple of dates for implementation, but the current temperature rise is less than half of the predictions by the Intergovernmental Panel on Climate Change. And it falls entirely within the range of past natural climate shifts that have occurred over the centuries, thousands of years. It is well within those range. So there isn't a urgent issue to pass this. There is no safety issue that's going to happen, and so I move Amendment L016 and ask it to be displayed.
Okay, the amendment has been moved and properly displayed. Would you like to tell us further about L016, Representative Pico?
Thank you, Madam Chair. This is very simple. It just simply removes the safety clause, puts a petition clause back in, and since there are some dates involved, it does move the October 1st, 2021 to April 1st, 2022, and one of the dates to take effect. There is no urgent need to put in place. Nobody's going to die. There isn't any safety issues involved. Budgets are not going to crash. So we don't have a need to have the safety clause in this sort of legislation, and I ask for an aye vote.
Okay, so Representative Soper. Soper.
Merci, Madam Chair. I appreciate it. So we actually just recently heard this bill. As a matter of fact, like this morning, we heard this bill. And one thing that came up as we were listening to it was why it is that the state's largest utility.
Excuse me, Representative Soper, Monsieur Soper, is this, are you speaking to the amendment or are you speaking to the bill?
Yes, I'm speaking to the amendment.
Okay, thank you.
Because I'm about to talk about dates.
Thank you.
Was that the state's largest utility asked to file a report on August 1st of, I believe it's 2022, and then all other utilities would be a year later at 2023. And so what this amendment also would still be in accordance with that, because it would come into force in April of 2022, which means you don't have any dates that are lost as far as what's being asked for in the bill. So it actually corresponds with the bill very well, and I would ask for a yes vote. Thank you.
Thank you. Is there any further discussion on Amendment L016? Seeing none, the question before us is the adoption of L016 to SB 21264. All in favor, please say aye. Aye. All opposed, please say no. No. The noes have it. The amendment is lost. Okay, to the bill. Representative Pico.
Thank you, Madam Chair. I want to stress that this bill really does go after the natural gas that runs into your home. And early on in this session, there was a lot of concern raised about whether or not people are going to come after natural gas. And we were assured that they weren't. Well, here it is. This bill is coming after natural gas. It's going to inject, whether you like it or not, various different types of energy into your natural gas pipelines. And that's probably okay. We do that in Colorado Springs Utilities. We pump propane in as a supplement. This is looking at other types of gas and so forth. But it's going to be very interesting process and a very technical process to ensure that all of your appliances are going to continue to work as they're designed, because they're designed to work on what's currently being sent into your home. Like I said, it was said earlier, they weren't coming after natural gas. This bill is doing exactly that. And it wants to insist that you change out your appliances either to electric, in which case you're putting an additional load on the electric grid, which is not currently equipped to handle it. The electric grid is having its issues already, and we start adding additional load to it, and this bill does that. It is going to go after the ability for you to heat your homes. The distributed generation of heat in your homes is at risk in this bill. And I ask for a no vote.
Minority Leader McKean.
Thank you, Madam Chair. That was one of my concerns coming into this session, that we heard rumors that we're going to hear bills that say you can no longer have a natural gas connection on new construction, that would be one direction of dealing with greenhouse gas emissions. I think what we need to remember, because we heard someone here say that structures are the largest emitters of greenhouse gases. Well, you might want to start defining structures. Current construction of especially residential units is the cleanest burning natural gas and cleanest burning possibly that you can get. To the point you're 98% efficient, you're not actually even putting out a lot of hot air, you're putting out mostly condensation. When we get to reality, just as we talked about the other night, we get to reality instead of fantasy. What we really start talking about is, what is it that we use today that we have proven through time? I'll take you back to the 1970s when everybody thought, oh, you know what we really need to do is put in electric baseboard heat. So they put in electric baseboard heat. It was incredibly expensive. It was incredibly inefficient. And the challenge now is that it's almost like we're trying to repeat ourselves because it sounds so good. Right? Oh, golly gee willikers, we're going to get rid of burning something and we're going to go to just having electric heat. What happened on Valentine's Day? What happened when you saw me in this well talking about the shortage that we had when my utility called to say, hey, we need you to cut back on heating your home on one of the coldest days of the year because right now we have shortage in supply of natural gas and the sun hasn't been shining very bright and the wind ain't been blowing. And this is the challenge we have, is the difference between fantasy and reality. And time again this year, we've come back to say, hold on. It is fine to have some aspirational goals. Aspirational goals are fine. Do not include them in policy. Do not include them when they are not tested. Do not include them when what you're really doing is setting up a structure that can only go one way. The only way this structure can go is to change the energy inputs in my home. And maybe that's what the sponsors want, is to say, okay, we know better. What we're going to do is we're going to tell you what to go do. We're going to create a structure by which all these goals have to be met, and therefore we know better, and we're going to tell you what you need to do. That's antithetical to the ideas that we live under in this country. Antithetical to the ideas of what we choose and the Western ethic of how we live. So when we get a bill like this that says, okay, no, we're not really going to tell you you can't have a hookup, but what you're going to have is all of this remediation of this effect. Now what you're doing is you're saying you don't get to choose. When I see a bill like this, it's a big bill that gets heard in committee in the morning, comes to the floor in the afternoon, I want to tell you that I actually think that were I in your position, I would hope that we said, you know what? This is a bigger conversation than one day. Actually, this is a bigger conversation than 3.5 hours. And I know you've done stakeholding, and I know that this bill's being worked, but this is a big conversation. This is a big conversation about what choice means in the state, what choice means for people who rely on this product, and what, although this has safeguards in it for certain disadvantaged communities, I'm a little more concerned with families sitting across the kitchen table, as I continue to repeat, who see their utility prices going up. And they sit there and say, look, because my utility had to do these things, now I'm paying more per therm. I am paying more to heat my home. I'm paying more to boil water on my stove. At some point, all the little things that we keep doing are adding up to real headaches.
Representative Hanks.
Thank you, Madam Chair. I remain discomfited by the process that we started with here. And some of the comments that we've been talking about this for a mere 3 hours have certainly piqued my interest, and I believe the people of Colorado need to know a little bit more about the state fiscal impacts of SB 21-264. So to that end, I'm looking at the revised fiscal note, which was drafted on the 28th of May, and it has 4 years of budget outlays, 4 fiscal years, 21, 22, 22, 23, 23, 24, 24, 25. For the first budget year, 21-22, the total expenditures are $427,330 and 3.2 full-time equivalents, FTEs. For fiscal year 22-23, total expenditures are estimated to be $592,350 and 4.8 FTEs. For fiscal year 23-24, total expenditures $673,062 and 5.6 FTEs. For fiscal year 24-25, $533,922 and 4.7 FTEs. I may come back to the summary of this legislation. It's a modest 6 pages long. But let's do this differently. A bill for an act concerning the adoption of programs by gas utilities to reduce greenhouse gas emissions. Bill summary. This summary applies to this bill as introduced and does not reflect any amendments that may be subsequently adopted. If this bill passes third reading in the House of Introduction A bill summary that applies to the re-engrossed version of this bill will be available at http://leg.colorado.gov. Section 1 of the bill defines a, quote, gas distribution utility, unquote, parenthetical GDU, as a gas public utility with more than 90,000 retail customers. The bill requires each GDU to file a clean heat plan, parenthetical plan, with the Public Utilities Commission, parenthetical PUC. A plan must demonstrate how the GDU will use the clean heat resources and meet clean heat targets, parenthetical targets, established in the bill. The targets are a 5% reduction below 2015 greenhouse gas, parenthetical GHG, page 2. Parenthetical GHG emission levels by 2025 and 20% below 2015 GHG emission levels by 2030. Section 1 makes a legislative finding that meeting these targets will facilitate the electric generating utilities sector's compliance with the state GHG emission reduction goals by reducing GDU's carbon dioxide and methane emissions. A plan may use qualified offsets as one method to meet the targets. A GDU that uses only clean heat resources in its plan to meet the targets is not subject to any other GHG emission reduction requirements during the 5-year period covered by the plan. If a GDU does not file a plan, the Air Quality Control Commission, parenthetical AQCC, will adopt rules to require the GDU to meet a 30% GHG emission reduction by 2035 when compared to 2015 levels. The PUC will initiate a rulemaking proceeding by August 1, 2021 to adopt rules that establish a cost cap for each GDU's compliance with its plan. The cost cap is 2% of gas bills for all of a GDU's full-service customer. A plan that costs equal to or less than the cost cap and uses clean heat resources to the maximum practicable extent need not meet the targets. A plan that uses only clean heat resources and meets the targets need not comply with the cost cap. The PUC is directed to approve a plan if the PUC finds that doing so is in the public interest. A municipal GDU must file a plan that demonstrates a 20% GHG emission reduction by 2030 with 2015 levels. Small GDUs may file a plan which is subject to the cost cap and must contain its own targets. Section 2 requires the AQCC to initiate a rulemaking proceeding by January 1, 2022 to define qualified offsets that plans may use to meet a target. The AQCC will start another rulemaking proceeding by January 1, 2029 to determine mass-based GHG emission reduction goals for plans for 2035, 2040, 2045, and 2050. Section 3 gives the Oil and Gas Conservation Commission authority over Class 6 injection wells used for sequestration of GHG, including through the issuance of permits. Be it enacted by the General Assembly of the State of Colorado, Section 1, in Colorado Revised Statutes, add 40-3.2-107 as follows. 40-3.2-107, Clean Heat Targets, Legislative Declaration, Definitions, Plans, Rules, Reports. Parenthetical 1, Legislative Declaration. The General Assembly hereby, A, finds that, page 3, finds that Roman numeral 1, in order to achieve Colorado's science-based greenhouse gas emission reduction goals and maintain a healthy, livable climate for Coloradans, Colorado must reduce greenhouse gas pollution from all sectors of the economy, including the built environment. Roman numeral 2. A significant source of greenhouse gas pollution from the built environment comes from the use of geologic gas to heat Colorado's homes and businesses and to heat water in those buildings, from the use of geological gas in commercial and industrial processes, and from gas leaks in the supply chain. Roman numeral 3. Improving the energy efficiency of Colorado's buildings will reduce pollution, improve comfort and safety, provide more resilience during weather extremes, and that's quite remarkable, Colorado. It should probably do exactly the opposite, and reduce consumer costs for heating and cooling homes and businesses, and Roman numeral 4, reducing the carbon intensity of gas delivered by utilities and switching from gas, space, and water heating to high-efficiency electric heating will reduce greenhouse gas pollution, ensure that Colorado makes progress towards its climate goals, and lead to improved indoor air quality. B, determines that, Roman numeral 1, there is significant potential to reduce emissions of methane from active and inactive coal mines, landfills, wastewater treatment plants, agricultural operations, and other sources of methane pollution through development of methane recovery and biomethane projects. And there are also significant economic development opportunities, especially in, page 4, especially in rural Colorado from development of this resource. Roman numeral 2, green and blue hydrogen have the potential to be zero or very low carbon sources of energy for use in a variety of sectors, including high heat industrial applications, zero carbon electricity generation, and the gas distribution. And Roman numeral 3, the development of hydrogen projects in Colorado has a potential to lower costs, contribute to economies of scale, and bring economic development opportunities. And C, declares that, Roman numeral 1, the General Assembly's intent in enacting this section is to implement a performance standard that will allow Colorado gas utilities to use available tools, including energy efficiency, biomethane, hydrogen, recovered methane, beneficial electrification of customer end uses, leak reduction on the utility distribution system that exceeds state and federal requirements, and is part of an approved system integrity plan, and other measures to achieve greenhouse gas emission reduction goals in a manner that maximizes emission reductions, cost effectiveness, and equity, while also requiring gas utilities to achieve the state's emission reduction goals and minimizing risk of stranded assets. Roman numeral 2, Colorado is focused on a transition to a decarbonized economy that recognizes the historic injustices that impact lower-income Coloradans and Black, Indigenous, and other people of color who have borne a disproportionate share of environmental risks while also enjoying fewer environmental, page 5, fewer environmental benefits. Roman numeral 3, the Commission must maximize greenhouse gas emission reductions and benefits to customers, with particular attention to residential customers who participate in income-qualified programs, while managing costs and risks to customers, including stranded asset cost risks, and in a manner that supports family-sustaining jobs. And Roman numeral 4, Decarbonizing Colorado's homes and businesses will require investments in building and equipment upgrades, clean fuel projects, and infrastructure upgrades. 2 definitions, as used in this section unless the context otherwise requires. A, biomethane means a mixture of carbon dioxide and hydrocarbons released from the biological decomposition of organic materials that is primarily methane and provides a net reduction in greenhouse gas emissions. And Roman numeral 2 includes biomethane recovered from manure management systems or anaerobic digesters that has been processed to meet pipeline quality. B, quote, blue hydrogen, unquote, means hydrogen derived from biomethane or geological gas paired with a process to capture and sequester associated carbon dioxide emissions. C, quote, clean heat plan, unquote, means a comprehensive plan submitted by a gas distribution utility or a municipal gas distribution utility that demonstrates projected reductions in methane and carbon dioxide emissions measured in carbon, page 6, measured in carbon dioxide equivalent that meets the reductions required in this section and aligns with Colorado's greenhouse gas emission reduction goals established in section 25-7-102, parenthetical 2G, at the lowest reasonable cost. As used in this subsection, parenthetical 2C, quote, lowest reasonable cost, unquote, means a reasonable cost mix of clean heat resources that meet clean heat targets established pursuant to this section as determined through a detailed analysis of available technologies and includes resource costs, market volatility risks, risks to ratepayers, systems operations costs, infrastructure costs, environmental justice goals, the social cost of carbon, and the social cost of methane in comparing the costs and benefits and benefits of alternatives and other costs and benefits as determined by the Commission. D, quote, clean heat resource, unquote, means any one or a combination of, Roman numeral 1, gas demand-side management programs as defined in section 40-1-102, parenthetical 6, Roman numeral 2, recovered methane, Roman numeral 3, green or blue hydrogen, Roman numeral 4, beneficial electrification as defined in section 40-3.2-106, parenthetical 6A. Roman numeral 5, coal mine methane as defined in section 40-2-124, parenthetical 1A, Roman numeral 2. Roman numeral 6, pyrolysis of tires as defined in section 30-20-1402, parenthetical 8. Roman numeral 7, methane emissions reduction on the gas distribution system attributable to an approved utility safety or integrity plan. Page 7. Roman numeral 8. Leak reductions from the distribution pipeline system that exceed state and federal requirements, and Roman numeral 9, any technology that the Commission finds is cost-effective and reduces greenhouse gas emissions associated with the distribution pipeline system or the combination of gas in consumer end uses. To qualify as a clean heat resource, all credits or severable tradable mechanisms representing the emission reduction attributes of the clean heat resource must be retired in the year generated and may not be sold. E, quote, cost cap, unquote, means a maximum cost impact established pursuant to to subsection 6A, Roman numeral 1 of this section for compliance with a clean heat target. F, division, unquote, means the division of administration created by section 25-1-102, parenthetical 2A, in the Department of Public Health and Environment. G, quote, gas, unquote, means geological gas, hydrogen, and recovered methane. H, quote, gas distribution utility, unquote, means a public utility providing gas service to more than 90,000 retail customers. Quote, gas distribution utility, unquote, does not include a municipal gas distribution utility. I, quote, geological gas, unquote, means methane and other hydrocarbons that occur underground without human intervention and are used as fuel. J, quote, greenhouse gas, unquote, has the meaning set forth in section 25-7-140, parenthetical 6, measured in terms of carbon dioxide equivalent using the 100-year global warming potential in the, page 8, in the most recent assessment report of the Intergovernmental Panel on Climate Change. K, I'm on page 8 of a 28-page bill, I guess, that nobody's seen yet. I'm going to take this to clean heat targets, and then I guess the snowflakes of yellow pages shall cease. No. L, innovative technology. I say again, quote, innovative technology, unquote, means a technology that, alone or in combination with other technologies, is greenhouse gas neutral or achieves a net reduction in greenhouse gas emissions and that has not been deployed widely in the United States. M, quote, municipal gas distribution utility, unquote, means a municipally owned utility that provides gas service to more than 90,000 customers. N, quote, pyrolysis, unquote, has the meaning set forth in section 40-2-124, parenthetical 1A, Roman numeral 5. O, quote, qualified offset, unquote, means a greenhouse gas emission reduction offset as determined by the Air Quality Control Commission pursuant to section 25-7-105, parenthetical 1E, Roman numeral 14. P, quote, recovered methane, unquote, means any of the following that are located in Colorado and are processed to meet pipeline quality standards if the division determines that its use will provide a net reduction in greenhouse gas emissions and that the resources are included in the state's greenhouse gas inventory. Roman numeral 1, biomethane, and Roman numeral 2, methane derived from A, municipal solid waste, B, the pyrolysis of municipal solid waste, except for page 9, the pyrolysis of source-separated recyclable materials that could otherwise be economically recycled as determined by the Department of Public Health and Environment. C, biomass pyrolysis or enzymatic biomass, or D, wastewater treatment. Q, quote, small gas distribution utility, unquote, means a public utility providing gas service to 90,000 retail customers or fewer. I say again, quote, small gas distribution utility, unquote, does not include a municipal gas distribution utility. I've been asked by leadership to hold here. But let me say this to Colorado right now. You can see we've had less than 3 hours to see this bill, to talk about it today. It's come through the transom here rather rapidly, and you might say there's an awful lot of information to be discerned, evaluated, and worked on. I don't think this is where it needs to be. I think we got a lot more work, but the unfortunate reality is we're probably going to be saddled with it.
Representative Woog.
Thank you, Madam Chair. I also oppose Senate Bill 264. Pretty concerned. I ran a bill early in this session, and it was House Bill 1034, and it was about consumers' right to choose natural gas or propane. And while Senate Bill 264 doesn't necessarily get rid of that right, it certainly looks like we're taking steps towards electrification. The reality is we've had many bills up here this session that keep taking those steps. So I was assured by some that probably support this Senate bill today that, oh no, we're never going to not have that choice to be able to use natural gas in our home and propane. But it just certainly looks like with this bill and with many others that that's the route we're going. So that's just very concerning for me. I've said this before and I'll continue to say it. I believe Colorado is at its best when we can use the resources we have. That's going to keep costs down. It's going to give people choice, which everyone wants. They don't want to be told they can use one thing. They want the choice for multiple things. That's what we love about this state. That's what we love about this country. And it just greatly bothers me that everything we're doing is moving towards electrification only. I will continue to support natural gas. I don't know how long it's going to last anymore in this state, but I certainly urge a no vote on Senate Bill 264. Thank you.
Is there any further discussion? Representative McKean.
Thank you very much.
Or, excuse me, Minority Leader McKean.
Thank you. Both are correct. Thank you very much, Madam Chair. It's an honor to serve with you.
It's an honor to serve with you.
Folks, I actually appreciate some of the time we took right there because, like we said, there may have been a lot of stakeholding on this bill, but it appeared, got through committee, and came to the floor in less than 3 hours. 3 hours is not enough time to really sit back and take a look at what we're doing. And certainly, if anything, we had a moment the other night where we had amendments pouring through, we had duplicate amendments adopted. So I usually say that sometimes hurrying takes too much time because what we're really doing is we're trying to rush through, and then we just absolutely need to slow down and talk about what it is. Talking about this is important because it affects people sitting down to figure out how to pay their bills. I cannot say this enough times. How many times are we going to ask the families of Colorado to squeeze a little bit more out of their pocketbook? How many times are we going to ask the families of Colorado that we know what's best for you and that you need to sign up for this or that or the other program? How many times are we going to ask the families of Colorado to deal with more regulation rather than more concrete or asphalt or education? How many times? Part of our job here is to make sure that we are the watchdogs for process. And what this bill does is put yet more bureaucracy in place with the AQCC. At some point, maybe they come back and tell us, we just can't do this anymore because you guys keep pushing everything on us. I think that's a very real danger. Vote no on this bill.
Thank you. Is there any further discussion on SB 21-264? Seeing none, the question before us is the passage of SB 21-264. All in favor, please say aye. Aye. All opposed, please say no. No. Okay, the ayes have it. SB 21-264 is adopted. Madam Assistant Majority Leader.
Thank you, Madam Chair. Members, I move that the committee rise and report.
Thank you. Seeing the motion, we will rise and report.
House will come back to order. Mr. Gregorio, please read the report of the Committee of the Whole.
Mr. Speaker, your Committee of the Whole begs leave to report is under consideration the following attached bills being the second reading thereof makes the following recommendations thereon. Senate Bill 88 is amended Senate Bill 137 is amended Senate Bill 240 is amended Senate Bill 264 is amended Senate Bill 271 passed on second reading in order to revise and placed on the calendar for third reading and final passage.
Representative Kipp. Members, you have heard the motion. There are amendments at the desk. We are going to go alphabetically by member's name. There's 3 different bills, 4 different amendments. We are going to start with the Geithner Amendment to Senate Bill 88. So, Mr. Gregorio, please read the Geithner Amendment, which is Amendment L72 to Senate Bill 88.
Representative Geithner moved to amend the report of the Committee of the Whole to reverse the action taken by the committee in not adopting the following Larson Amendment L72 to Senate Bill 88 to show that said amendment passed and that Senate Bill 88 is amended passed.
Representative Geithner.
Thank you, Mr. Speakers. I move the Geithner Amendment to the Committee of the Whole.
Representative Geithner, that's been properly moved and displayed. Any further discussion? Representative Geithner.
Thank you, Mr. Speaker. You know, members, I think this bill, you know, we heard from the sponsor, or not from the sponsors, I'm sorry, from some of the other members in the chamber about the progression of 88 and the length of time that it has even taken to get to this point. And I don't argue that. I can recognize the work that's gone into it. I can recognize the length of time that it has taken to get this far. But I think it's only appropriate that, and actually I'll concede on another point too. I think one of the sponsors spoke about how 88 does bring in a level of, it changes the protections that are currently in and around the public sector specifically, and that's good and well and fine as it should be. However, there is still no parity. And what it really says to me, and it says to others, is it says that the victims are going to be looked at differently. That somehow the act is more egregious if it's done in the private sector than if it is done in the public sector. And that doesn't sit well with me. That we would embark upon a journey here as legislators where we're looking at policy and we will say, hey, we're willing to do a fix, but only this much. If we're going to hold the private sector to a standard, which is $500,000 and $1 million, and that's the cap for victims who have been sexually abused, then by God, the government should be held to the same exact standard. And I say the government because these are the public entities. These are public schools. These are anything and everything related to the public sector. The crime of this magnitude against a child does not get a pass, in my opinion. Everybody who is responsible for that heinous act should be held responsible to the fullest extent of the law and should not appear to get any type of a break. You know, there was a piece of policy a couple days ago, and it was insinuated that perhaps a certain amendment said that a certain life wasn't as valuable. Without this amendment, this piece of policy, in my opinion, does that. The trauma that is endured by the child, no matter at what point they come back to address it, is a trauma that remains, and the government should not get a pass. And without the amendment that I am trying to work to put on this, that's what is happening. I think the cap is somewhere in the neighborhood of $387,000, $386,000. I don't have the committee report with me, but if I recall correctly, that's the cap for the government. That's the cap for the public sector. The cap for the private sector is $500,000. Why is the government treated differently? Why does the public entity get a pass? The act is the same regardless of if it happens in the private school or the public school. The trauma that is endured by the victim is the same whether it happens in the public school or the private school. We have no business sitting here and saying that one gets to be treated differently. I urge us to adopt this amendment. Let's bring parity to the bill and as it pertains to this specific piece. Let's look after the victims. Let's put the victims first, not the public sector. Let's put the victims first, not the public sector. I urge a yes vote.
Representative Soper.
Thank you, Mr. Speaker. I'm conflicted here. I do like the amendment, but I'm going to ask for a no vote on the amendment. And I'll explain to you why. So under current law right now, a victim cannot seek compensation for damages of this kind, of the cover-up of a child rape or sexual molestation in a youth-related activity because of sovereign immunity. So right now, the victim gets nothing. There is no state law claim that can be brought. Prior to 1971 in this state, we had to waive immunity for a victim to sue a state actor or a state entity for anything. Then there was a horrible accident that happened, and in 1971, we implemented this body, the CGIA, the Government Immunities Act. And it's been tied to inflation. It's been amended a couple of times since, minorly. But it wasn't until 1986 that we actually engaged in tort reform. So for the entire history of our state until 1986, the sky was the limit as far as what the jury determined the damages should be worth. And by damages, I mean economic damages and non-economic damages. So economic, those would be your actual receipts from your hospital bills. Non-economic would be pain and suffering. Then we also allow for punitive damages. But when comparing the CGIA, the 1986 tort reform, at no point in history has the CGIA ever been equal to the 1986 tort reform. And this is because this is a rare exception where we've actually waived immunity to be sued in our own courts. It stems from ancient England and the principle that the king cannot be sued in the king's own court. So under current law, Section 24-10-106, as a state, we've put in statute when we will waive sovereign immunity. These are for things like involving a motor vehicle that's owned or leased by a public entity, for operations in a public hospital or correctional facility where we're talking about the actual building, for dangerous conditions that we've created that exist on a public highway, for dangerous conditions that exist in certain buildings such as jails or hospitals, for failure to maintain water facilities, for failure to do an employment background check. Those are the only times when we've said we would waive immunity unless we actually explicitly do so. And I can tell you we rarely ever do that, which is why Senate Bill 88 is so significant, is because we are saying we're going to add to this list. We're going to waive sovereign immunity and actually give victims the opportunity to make their case in court, and if a judge and jury decide, award an award of damages. So coming full circle back around, if we were to move it to where it would be the same, we actually all of a sudden would place the rest of Colorado law out of balance. Because balance right now is the CGIA kicks in to knock down a higher award. And then you would have to apply the same argument to everything else that happens by a state actor in state government. And so with a no vote, it's actually recognizing the fact that these are horrible, horrible things of covering up a molestation or rape of a child by a state actor, state institution, and that they should be compensated for that. So I'd urge a no vote. Thank you.
Representative Van Winkle.
Thank you, Mr. Speaker, and I do appreciate the history lesson and appreciate our Judiciary Committee and the fine work they do, but just because that may have been the law of yesteryear, that doesn't make it right and that doesn't make it just. I am asking for a yes vote on this amendment because it does put victims first and not government. It is shameful to me that we would put into law that a victim and their trauma is valued less if they are sexually abused, raped, or molested by a predator such as a Jerry Sandusky, if their rapist is a person like him on a government payroll in a position of trust. Those crimes shouldn't be treated differently, and the victim shouldn't be treated differently either. I ask for a yes vote on this amendment, and thank the sponsor for bringing it.
Representative Weissman.
Thank you, Mr. Speaker. Members, as I did when we debated this a little bit ago inside the committee of the whole, I'm going to ask for a no vote, and I'll say a little bit about why. First, you know, we've talked about a journey, and I want to share a little journey that I've been on over years in judiciary, engaging with the kind of organizations representing the kind of people we're talking about here today. This may seem a semantic point, but it's an important one. I try to not use the word victim. You know, we use that in the law sometimes, Victim Rights Act. A victim is someone to whom something has happened. A victim is somebody who has had all the agency taken away from them. And that's what's happening in the moment. A survivor is somebody who has begun to work through that and to reclaim agency in their lives and to get past that dark time and that trauma. I did not appreciate this in 2017 when I walked in here and first began to serve on judiciary, but I do now. And if you engage with this community, you will hear people speak of themselves not as victims but as survivors for that reason, because it is about agency. It is about something horrible may have happened to you, but you are more than the worst thing that has ever happened to you. So I would just ask that we contemplate that and remember it and choose our words carefully down here. That said, Mr. Assistant Minority Leader, you said that government should not get a pass. And I agree, and this bill holds government accountable for things that happened a long time ago for the first time in years and decades. Survivors have been coming to this place for years and decades trying to win some kind of pathway to justice like this. This is holding the government accountable in exactly the same way that government is held accountable for everything else it does. And some of the examples that Rep. Soper alluded to. You know, sir, you said that government should be held accountable to the fullest extent of the law, and this bill does that up to that same figure. Currently, the cap is $387,000 for recovery against a government entity. So folks know that amount goes up by inflation every couple of years. I think it's the Secretary of State that's directed to do the calculation. You can look it up. So that will keep up with inflation. You know, it's again, we may have opinions about the adequacy of that amount. I know that we all do, and we should. But there's at least that mechanism so it doesn't get inflated away. It's a small but important detail. It matters to me, and it should matter to all of us, that the sponsors and the advocates introduced the bill with the usual conformity to the whole rest of CGIA. That was a choice that they made so that they could win what they thought that they could win. And yes, it was taken away in the Senate, and it was restored by an amendment in House Judiciary Committee that the sponsors and the advocates agreed to. We are called representatives. We are here in a representative capacity. Yes, our own judgment is vitally important, and I am a big believer in the prerogative that flows to all of us from Article 5 of the state constitution. But sometimes we are here to listen and to try to stand behind those who've come to this place after years and decades asking for some relief. And that is how I'm going to vote on this amendment. I'm going to vote no because I believe that to vote the other way jeopardizes something that we are so close to doing, finally, not just this session, but after years and decades, Are there issues with government immunity? Yes, we can talk about that. Do not settle those issues on the backs of survivors who are this close to winning, healing, and justice. I ask for a no vote.
Assistant Minority Leader Geithner.
Thank you, Mr. Speaker. And I think one of the questions I have is why is this in jeopardy? How does this amendment jeopardize this policy's success? Whether you want to call them victims or you want to call them survivors, why should we be telling them that under one circumstance you're entitled to this type of relief, but in this one, not so much? The ability for them to seek justice, equal justice for that survivor, that's what's been in jeopardy all along. And it will continue to be in jeopardy if we don't pass this. That's what's in jeopardy. If you want to call them survivors, if you want to call them victims, I get that, and I get the arguments for both sides. But I have to say that I feel, actually, I'll even back up. I can't tell you how many amendments, or not amendments, I'm sorry, how many emails I've gotten since this amendment has been run on just this bill just today. There are people watching, there are victims watching, there are survivors that are watching right now. And they're urging that we adopt this amendment. I've had people that have written to me this session specifically. And we've made some changes to criminal justice, some good, some bad, some necessary in my opinion, some not necessary. And I actually had a constituent of mine say that they felt like this year was the war on victims. That really hit me. All we're asking for in this amendment is parity. Parity shouldn't jeopardize policy at all. We're saying that if the private sector is held to a standard, well then so by God should the government and the public sector as well. It goes back to that fundamental belief that the trauma inflicted upon that child knows no difference based on the perpetrator. It says that we, as a body, hold both equally accountable. That's what a yes vote means. I urge us to adopt this amendment. Let's not stand in the way of survivors. Let's bring parity to an issue that is needed because they're crying out. And I'm getting the emails in just the last hour and a half because they're watching, and they should be, crying out. So let's answer those cries. Let's do what we need to do and vote yes on this amendment.
Representative Sandridge. Okay, is there any further discussion? Seeing none. The question before us is the adoption of the Geithner Amendment L072 to the report of the Committee of the Whole. Mr. Gregorio, please open the machine and members please proceed to vote. Representative McLaughlin, how do you vote?
Yes.
Representative McLaughlin votes yes. Representative Tipper, how do you vote?
No.
Representative Tipper votes no. Bockenfeld, Exum, Gonzalez, Gutierrez, Herod, Snyder, Williams. Please close the machine. With 29 aye votes, 35 no votes, and 1 excuse, the Geithner amendment to the report of the Committee of the Whole is lost. Mr. Gregorio, please read the Pelton Amendment to Senate Bill 137, which is L63.
Representative Pelton moved to amend the report of the Committee of the Whole to reverse the action taken by the committee not adopting the following Pelton Amendment, L63, to Senate Bill 137, to show that said amendment passed and that Senate Bill 137 is amended passed.
Representative Pelton.
Thank you, Mr. Speaker. I move the Pelton Amendment to the Committee of the Whole. This amendment strips out the clean syringe program out of 137.
It has been properly moved and displayed. Representative Kennedy.
Thank you, Mr. Speaker. Members, I ask for a no vote on this amendment. This is an evidence-based program that is going to save lives, prevent the spread of disease, and help more people get help.
Any further discussion? Seeing none, question before us is the adoption of the Pelton Amendment, L63, to the report of the Committee of the Whole. Mr. Gregorio, please open the machine, and members, please proceed to vote. Representative McLaughlin, how do you vote?
Yes.
Representative McLaughlin votes yes. Representative Tipper, how do you vote?
No.
Representative Tipper votes no. Please close the machine. With 27 aye votes, 37 no votes, and 1 excuse, the Pelton Amendment to the report of the Committee of the Whole is lost. Mr. Gregorio, please read the first PICO Amendment, which is L15 to Senate Bill 264 to the report of the Committee of the Whole.
Representative Pico moved to amend the report of the Committee of the Whole to reverse the action taken by the committee not adopting the following PICO Amendment, L15 to Senate Bill 264, to show that said amendment passed and that Senate Bill 264 is amended passed.
Representative Pico.
Thank you, Mr. Speaker. I move the first PICO amendment to the report of the Committee of the Whole. Ask for an aye vote. This amendment puts an objective criteria on the implementation of the bill. If climate change is occurring to the fraction of a degree that you fear it is, this amendment will self-destruct. If it isn't, then it won't. What do you have to lose? I ask for an aye vote.
Representative Burnett.
I ask for a no vote.
Is there any further discussion? Seeing none, the question before us is the adoption of the first PICO Amendment to the report of the Committee of the Whole. Mr. Gregorio, please open the machine, and members, please proceed to vote. Representative McLaughlin, how do you vote?
No.
Representative McLaughlin votes no. Representative Tipper, how do you vote?
No.
Representative Tipper votes no. Please close the machine. With 24 aye votes, 40 no votes, and 1 excuse, the first PICO Amendment to the report of the Committee of the Whole is lost. Mr. Gregorio, please read the second PICO Amendment, which is L16, to the report of the Committee of the Whole.
Representative Pico moved to amend the report of the Committee of the Whole to reverse the action taken by the committee not adopting the following PICO Amendment, L16 to Senate Bill 264, to show that said amendment passed and that Senate Bill 264 is amended passed.
Representative Pico.
Thank you, Mr. Speaker. I move the second PICO amendment to the report of the Committee of the Whole and ask for an aye vote.
It's been properly moved and displayed. Representative Burnett.
Thank you, Mr. Speaker. I ask for a no vote.
Is there any further discussion on the second PICO Amendment to the report of the Committee of the Whole? Seeing none, the question before us is the adoption of the second PICO Amendment to the report of the Committee of the Whole. Mr. Gregorio, please open the machine, and members, please proceed to vote. Representative McLaughlin, how do you vote?
No.
Representative McLaughlin votes no. Representative Tipper, how do you vote?
No.
Representative Tipper votes no. Please close the machine. With 24 aye votes, 40 no votes, and 1 excuse, the second PICO Amendment to the report of the Committee of the Whole is lost. That brings us to the report of the Committee of the Whole. The question before us is the adoption of the report of the Committee of the Whole. Mr. Gregorio, please open the machine, and members, please proceed to vote. Representative McLaughlin, how do you vote?
Yes.
Representative McLaughlin votes yes. Representative Tipper, how do you vote?
Yes.
Representative Tipper votes yes. Please close the machine. With 41 aye votes, 23 no votes, and 1 excuse, a report of the Committee of the Whole is adopted. I think, let's move to announcements and introductions quickly. And there's a $20 bill there. I think that's to pay my fine from a couple weeks ago. Pretty sure that's mine. Pretty sure. Representative Byrd, or Majority Leader Eskar.
I'm going to play the honor system, folks. I'm going to leave it sitting on my desk, and if it was yours or you lost $20, there you go.
Yep, sounds good. Representative Byrd.
Thank you, Mr. Speaker. I've been waiting all afternoon to come up because I haven't mentioned finance for a while. So, members, upon adjournment in House Committee Room 112, Friends and Fans of Finance will be meeting to hear the following bills in the following order. We'll first hear Senate Bill 33, second, Senate Bill 60, Senate Bill 293, and last on the calendar will be Senate Bill 273. Thank you.
Representative Weissman.
Thank you. And while we're talking about straight 20s, I actually saw another one on the floor over there, so check your pockets. I don't know.
Don't worry about it.
Judiciary, again, we have unattended to business. Finance needs to meet, and then let's plan on Judiciary meeting immediately upon adjournment of Finance to continue the one bill that we have. Let's say Old State Library. I think that's where we're going to be. See you then.
Representative Tipper.
Yes, those are my $20 bills.
Representative Herod.
Thank you, Mr. Speaker. Members of the Appropriations Committee, we will meet this afternoon to hear 176, 33, 273, 60, 91, and 293 if those are referred out of committee.
All right, let's do some, we don't have much. We have a couple things. We're going to do these things. Let's do conference committee reports.
First report of the First Conference Committee on House Bill 21-1065. This report
Conference
adopts.
committee reports will be printed in the journal. Message from the Senate.
Mr. Speaker, the
Message
Senate.
from the Senate will be buried in the journal. Message from the reviser.
We herewith transmit.
Message from the reviser will be printed in the journal. And that's all. Hang on for 1 second for introduction of bills. Because in order, so we'll be in a brief recess. Introduction of bills. Wait, sorry. The House will come back to order. Introduction of bills.
Senate Bill 21-293 by Senators Hansen and Rankin, also Representatives Eskar and Gray, concerning property taxation and in connection therewith establishing subclasses of residential and non-residential property for the 2022 and 2023 property tax years, temporarily reducing the assessment rate for property classified as agricultural property or renewable energy production property from 29% to 26 and 0.4% for property classified as multifamily residential real property from 7 and 15/100% to 6 and 0.8%, contingent on the assessment rate not otherwise being reduced by an initiated measure, and for all other residential real property from 7 and 15/100% to 6 and 95/100%, restructuring the assessment rate laws, expanding the property tax deferral program to allow taxpayers to defer increases in property taxes in limited circumstances, and making an appropriation.
Senate Bill 293 will be assigned to the Committee on Finance. Introduction of resolution.
HJR 21-10005 by Representative Garnett, concerning the approval by the House of Representatives of the Speaker's appointment of Ann Kao to fill the House appointee vacancy on the Independent Ethics Commission.
House Resolution 1005 will be laid over 1 day per the rules. All right, with that, Majority Leader Eskar. Majority Leader Escar.
Thank you, Mr. Speaker. I move that the House stand in recess until later today. Members, we are going to committees. Check your phones, and whoever communicates with you that we're coming back to the floor will let you know when we are coming back to the floor, because we still have lots of work to do. Thanks so much for all your work.
Seeing no objection, the House will stand in recess until later today.